is everybody. Today is February 26th, and it's 9:31 in the morning. Welcome to our California Board of Occupational Therapy meeting. Ada, can we please take a roll?
Beata Marcos,
Here.
Christine Whitlisbach,
Oh, you have one.
Ada Boone Hurl here, Louis Arabint,
Here.
Matthew Greco,
Here.
Vicky Santos,
Vicky, if you are here, please let us know that you're here. We cannot hear you. Hmm? Oh.
Just let's put the roll on recording, please.
The roll on the, okay, let's do that, please.
Beata Marcos,
Here.
Christine Whitlisbach,
Here.
Ada Boone Hurl here, Louis Arabint,
Here.
Matthew Greco,
Here.
Vicky Santos,
Is she on at all? As long as she does not have her camera on, she does not count as present. So once she returns with her camera, we can either retake roll or announce that she has arrived. Do we have quorum without her?
We do.
We do.
and we also have Erin Schweer.
Here. Could we just quickly contact her, see what's happening?
Yeah.
Let's just hold off for a second just to see where she's at, so this way we don't have to go back and forth. You need my phone?
There she is.
Can you hear me now?
Yes,
Sorry about that.
no worries. Just let us know that you're here.
I'm here.
Okay, we have a quorum. Thank you so much. Moving on to agenda number 2, President's Remark, information only. Just wanted to thank DCA for hosting us in this lovely room. It's so professional. I always love it. And thank you, everybody, for being here. And just one important remark that I would like to make is that to all the board members, that from now on, when we make a motion, we have to state clearly on what the motion is. So this way it helps the staff to have the correct, for the meeting minutes, correct information. So, so please do not do the so moved. I would really appreciate that. So just whatever, even if it's accepting the board meeting minutes, just state the board meeting minutes and then whatever the minutes are for the date, okay? We would really appreciate that and staff as well. So thank you so much for that. All right, moving on to agenda number 3, board member remarks. We'll go from left to right. Louis or Aaron?
Good morning, everybody. Glad to be here.
Okay.
I'd just like to report that things are greatly improving in our student access to NBCOT, and we appreciate the OT Association of California leading that charge. And so we have improvement, which helps the state. Thank you.
Thank you. Nothing.
Nothing, thank you.
Thank you very much. Thank you, Ada, for the update. Moving on to agenda number 4, public comment for items not on the agenda. This is also the time for whoever would like to introduce themselves. We will start in person and then we'll go to WebEx. Yeah, sure.
Good morning, Sam Urafidi, and I'm here
We need to
representing.
come up to a mic.
Don't forget your license number either. I'm just kidding.
7438.
Thank you. Good morning. Sam Urafidi, representing the Occupational Therapy Association of California, serving as the president, license number OT 7438.
Thank you very much for that information. You're good. All right, thank you so much. Somebody just joined our meeting. if you would like to introduce yourself, that would be this time. You don't have to, but if, okay. Well, welcome. Thank you for being here. And I would like to go to WebEx and see if we have any public comments or any introductions via WebEx.
All right, WebEx, now is the time to raise your hand if you wish to make a public comment. You can do so by tapping that hand button at the bottom of the screen. Dial-in users, dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few seconds now to see if we have a request for public comment. Seeing no request online, do you wish to continue?
Yes, please. Thank you very much. Moving on to agenda number 5, review and vote on approval of December 5th, 2026 board meeting minutes. Does anybody have any comments? Oops, I stole a pen.
Move to approve the minutes for the meeting December 5, 2025.
Might have a comment.
We could do second and then open for discussion.
The discussion.
Oh, pardon me.
Now we can go back to the
Okay.
discussion.
I'm just clarifying that the October 29, so I am in the, on page 8, looking at the upcoming meeting dates. And I'm just confirming that October 29th and 30th is the correct set of dates, not the 5th and the 8th. I'm just, in my old notes, I had the 5th and the 8th. And
For October?
no, of November, the following week.
Yeah, no, that was, I think, last year.
Okay, thank you very much.
Yeah. I mean, we can always go back to revisit if people are not available or whatever, but yeah, this is what we were talking about last time.
Thank you.
Sure, thank you. Any other comments regarding this item before we go to public comment on WebEx? No? All right, David, can we please go to public comments via WebEx? And then we'll have it here too, I guess.
All right, WebEx, now is the time to raise a hand on agenda item 5. If you'd like to make a comment, tap that hand button at the bottom of the screen. Dial-in users, dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a moment now to see if we have a request for public comment. Seeing no requests, do you wish to continue with the agenda?
Yes, thank you very much. And Vicky, if you have any comments at any time, you can always just unmute yourself and let us know, okay?
Okay, thank you.
Thank you. Moving on to agenda number 6.
Or do you want to vote?
Oh, yeah, let's vote, please. Sure, that would be great. Thank you.
Beata Marcos?
Yes.
Christine Whitlisbach?
Yes.
Ada Boone Hurl, yes. Louis Arabet?
Yes.
Matthew Greco?
Yes.
Vicky Santos?
Yes.
Aaron Schwer?
Yes. Motion carries. Thank you very much. Agenda number 6, update from the administrative committee.
I'll be happy to share what the administrative committee has been discussing lately. The administrative committee has mostly taken on the role of being the sort of ad hoc sunset committee this year. We have recently drafted our opening statement for the hearing, and we have found out that our hearing date is going to be March 24th. And that's about it for updates from the administrative committee, but they are important ones.
Thank you for that. Do we have any questions? No? I guess just gonna, moving on to agenda number 7.
Okay, can I ask one question?
Sure.
What committee is that in front of?
It's the joint, I don't want to get the name wrong. Joint Sunset Review Oversight Hearings. And that is a committee from both the State Assembly and the Senate. Should be.
Okay.
Just not talking into it.
And where
The
is it?
This year, it's going to be in Sacramento, and I can pull up the exact location.
I saw it somewhere. Oh, you got it?
So to respond to the committees, that's the Assembly Committee on Business and Professions and the Senate Committee on Business, Professions, and Economic Development. And then I can get the location in Sacramento where those are going to be in just a minute.
Thank you.
We're waiting for the exact address. Just for the record.
The hearings this year will be held in room 1100 at 1021 O Street in Sacramento.
Thank you. Any other questions? All right, moving on to agenda number 7, review and vote on acceptance of the April 2025 practice committee meeting minutes.
You want me to do it?
Sure.
Or it's up to you.
Take it away.
Okay. So I'm going to take this because I'm the chair of the practice committee. We've already talked about what occurred at the practice committee meeting on April 25th, 2025. So now we're bringing to you the meeting minutes from that date. Basically, what happened at this meeting is we met with Teresa Brenninger from ACOT. She's the director of accreditation there. And we talked about recommending to the board a change in the training and education hours for people who are applying for their advanced practice in hand therapy. We are still working on language for that, but what's pertinent to today's meeting is the fact that what came out of that meeting was Teresa recommended that either the board and or OTAC and or individual practitioners would recommend to ACOT in the future adding language to the ACOT standards that would cover requiring entry-level programs to offer
To
education.
include
Yeah, education
on
in
the
surgical.
procedures of the upper extremity
Yeah,
and
surgical.
postoperative course.
Yes, so I'm going to make that a little bit more clear. That courses, entry-level courses for occupational therapy offer training in surgical procedures of the upper extremity. So that is the recommendation, and their postoperative course. That is the recommendation that came out of that meeting from Teresa at ACOT, and that will be pertinent to talking about some things later in the meeting today. So we are tasked now with accepting these minutes. Are there any questions? For the record, I looked them over and they seem to be correct.
I move to accept the practice committee meeting minutes of April 25th, 2025.
I'll second it.
Okay, any further board discussion? Do we have any public comments? Can we please open it on WebEx?
All right, WebEx, if you'd like to make a comment on agenda item 7, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a moment now to see if we have a request for public comment. Seeing no request, you wish to continue with the motion?
Yes, thank you very much. Let's take, oh, sure.
When you say surgical procedures,
Can you speak into the mic?
when you mention surgical procedures, what does that exactly mean?
So education about what sort of surgical procedures occupational therapists would typically see.
Like rotator cuff injuries,
I'm sorry, what did you say?
rotator cuff injuries, or
It could be that, although shoulder is
or
outside.
part fractures?
Well, so in California, hand therapy is defined as surgery or injury to the hand, wrist, or forearm. So it would be surgical procedures at that level. So carpal tunnel syndrome, carpal tunnel releases, flexor tendon injuries and repairs, things like that.
Oh, does it cover the shoulder?
No, because shoulder is outside of advanced practice. That's just general OT.
All right, thank you.
Let's take a roll, please.
Beata Marcos,
Yes.
Christine Whitlisbach,
Yes.
Ada Boone Hurl, yes. Louis Arabit.
Yes.
Matthew Greco,
Yes.
Vicky Santos,
Yes.
Aaron Schwer.
Yes. Okay, motion carries. Thank you very much. Thank you, Christine, for the information. Moving on to agenda number 8, discussion and possible action to letter from Occupational Therapy Association of California to the Accreditation Council on Occupational Therapy Education regarding the inclusion of surgical procedures of the upper extremity and their post-operative course as an education standard. Did everybody have a chance to look at the letter from OTAC?
It's a great letter. Thank you.
Do you wish to make any further comments regarding the letter?
Sammy Rafidi here. Thank you. Now that Christine, you have clarified what parts of the upper extremity, I almost wonder if that should be included in that letter to ACOTE, that it would just be the wrist, hand, and forearm.
Yeah, I had that realization as it was coming out of my mouth.
Yeah.
So
Because I forget that that's how advanced practice was defined. And I'm glad that Louis asked that question because it brought it back.
yeah, it would be more helpful to the state of California if it were couched that
That way.
way. We still have time.
Yeah.
Yeah.
Okay. Thank you.
Thank you. Do you have any questions regarding the letter or? So then did the board members have time to review the letter of our support towards OTAC? What do we think?
Yes. It's a good letter, but perhaps in light of Louis' question, we should try to be a little more specific.
Sure.
What
Yeah.
what we're looking for,
We can definitely add what constitutes the upper extremity to the letter.
what we're looking for, what
Yeah.
we're requesting. Yeah.
I do think that the letter supports the intention of the original conversation and recommendation from ACOTE, and in conjunction with the letter, I think it brings good full support.
I think if we define, include the definition of upper extremity, I think would be much more clearer. Yeah. Include shoulder, maybe elbow as well.
I agree with that as well, because someone that is not in the field, it does seem like, oh, what, surgery, what does that all entail? So I'd like us to add that information so that it's clear.
Thank you. Is there a deadline to submit the letter of support or no?
I don't even think they're working on it yet. Are they the next?
Sammy Rafidi again. When we received a response from ACOTE, they basically said that they're always looking at the next wave of standards and they're every 5 years or so. So they usually have open forums at AOTA's annual conference, and including suggestions, recommendations. It's always open on their website, so you could submit the letter anytime. We'd want it in there before they actually change the next day code standards, which we just had them changed for 2023. So the next grouping would likely be 2028. I think. I'm
I
looking at,
agree with that calculation that 2028 would be the next title of the standards. So they'd probably, they wouldn't go into effect until 2030
Right.
is about the pattern.
Yeah.
Yeah.
The
so
2023 goes into effect 2025,
that's right.
correct.
or went into effect 2025.
And then it's about a 7-year window between the final number and the next final number, 2023 and 2030.
And depending upon the interpretive guides, there may be a way to enhance a current standard before then. So it would just have to be reviewed.
That's an excellent point.
But that would be something up to ACOT that they would
Right,
receive the
exactly.
feedback. And if the feedback is aligned with a current existing standard and could be just an increased interpretation of the standard and increased definition of the standard, then ACOT could change it prior to a full iteration of the standards.
I didn't get the sense that that's what Teresa was
Probably not.
wanting to do.
Probably not.
It's a big ask.
Yeah.
Yeah. But yes, you're right. It's another way.
David, let's go to WebEx and see if we have any comments regarding these letters.
All right, WebEx. If you'd like to make a comment on the letters, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few seconds now to see if we have a request for public comment. Seeing no requests, do you wish to continue?
Yes, thank you very much, David. Okay, so I guess at this point, we're just gonna modify the letter, so we don't have any motions. We don't need any motions. We'll just bring it to the next meeting. Okay. Thank you, everybody. Thank you, Thamia, for all the clarifications. All right, agenda number 9, presentation from the Office of Professional Examination Services on the exam validation process. Hello, welcome. Good morning.
All right. I'm not going to be able to see my slides, but that's okay.
Oh, we might be able to get those on the, David, do we have the slides? Yep, we do.
Okay. If I saw like half, that could be good.
Your microphone on?
It's green. Here, there we go. All right. Well, good morning. I'm Amy Welch-Gandy from the Office of Professional Examination Services. Unfortunately, my colleague Karen Okasich could not be here with us today, but I am going to be going over our process and who we are, what we do at OPES. So in this presentation, I will provide an overview of OPES, briefly discuss licensure examinations, then outline the steps in an occupational analysis and national review processes, and then I can answer questions following the presentation. So at OPES, our mission is to protect consumers by developing fair and valid licensing examinations. OPES serves boards and bureaus under DCA in examination development, examination administration. We work with all of the boards and bureaus to develop and maintain California licensing examinations or answer questions about examinations. For boards that use national exams, we evaluate their national examinations that are used for licensure in California. OPS also manages a DCA-wide computer-based testing contract for licensing examination administration, and that's with DCA's exam administration vendor, PSI. OPES provides 3 licensing examination services to DCA boards and bureaus. The first is developing licensure examinations and evaluating the validity of national examinations used in California. The second is providing recommendations to boards and bureaus on the issues related to licensing exams, such as exam requirements, exam wait times, adaptation of exams into multiple languages. OPES test specialists make these recommendations based on law, policy, regulation, professional guidelines, and technical standards. And then our third service is managing that computer-based testing contract. And the unit that does that is called IESP. In this slide, these are the DCA entities that OPES works with, either under intra-agency contracts or part of the DCA's computer-based testing contract. And next slide, please. Business and Professions Code Section 139 was created in 1999, and it applies to all DCA boards and bureaus. Business and Professions Code Section 139 was developed to help ensure that all licensure examinations used by DCA are psychometrically sound, job-related, and legally defensible. They must be based on a current occupational analysis of the profession, and they must meet technical standards for validity. Business and Professions Code Section 139 requires that boards submit to DCA annually, indicating the date of their most recent occupational analysis and other information about their licensure examinations. OPES compiles this information for DCA, who then submits this information to the legislature. Business and Professions Section 139, Business and Professions Code Section 139 also mandates that national examinations be reviewed in accordance with policy guidelines set by OPES. And these are the policy guidelines that were developed by OPES to help boards and bureaus implement the mandate of Section 139, which is an ongoing process. First, OPES has developed a specific licensure validation policy for DCA. This policy is updated as industry standards evolve. OPES has also developed these other policies and department memorandums that provide a structure for the examination development and evaluation work that we do. OPES policy specifies the standards for educational and psychological testing as the technical standards to be followed when evaluating licensure examination programs. We refer to them as the standards. These standards are universally accepted by testing professionals. The standards were specifically designed to help ensure that examinations are fair, valid, and reliable. Taking a look at the big picture, the purpose of licensing and DCA's mission is to protect the public. And the purpose of licensure examinations is to identify those practitioners who can practice safely and competently from those who cannot. Licensure examinations must be developed to provide a valid and reliable method for doing this. And to be fair, when making decisions about who is legally allowed to practice, we must focus on entry-level tasks and knowledge that is important for public protection. When licensure examinations are developed, it is critical that examinations protect consumers while not limiting access to occupations. It is a balance between these two goals, and we find that balance by ensuring that examinations focus on entry-level tasks and knowledge critical for public protection. Subject matter experts, or SMEs, are licensees who are currently practicing and in good standing with the board. SMEs must be involved in all phases of licensure examination development. Taking a look at the big picture, the purpose of licensing and DCA's mission is to protect the public. And the purpose of licensing examination is to identify those, okay, I'm reading the same slide again, sorry. Next slide, please. The first step in developing a valid and reliable exam is to develop a detailed description of the content domains to be measured. We do this by conducting an occupational analysis, which can also be called a job analysis or a practice analysis. The occupational analysis is a study of the profession designed to identify the important tasks new licensees must be able to perform safely and competently at the time of licensure. The occupational analysis is the first step in what we call the examination development cycle. The results of the occupational analysis include a detailed description of practice, which is divided into content domains and an outline for developing licensure examinations. The next step is to work with SMEs to write and review test questions, construct the examination, and determine the passing score, or sometimes called a cut score. Subject matter experts play an essential role in licensing examination development and validation. SMEs are licensees who are in good standing with the board. We rely on SMEs to know what is happening in the profession and what kinds of knowledge and skills a licensing exam should measure. SMEs write examination questions, construct examinations, and set passing scores. They also assist OPES with evaluating the validity of national examinations. In short, SMEs are involved in almost every important aspect of OPES's work, and the board is primarily responsible for recruiting subject matter experts to participate in this development. SMEs should represent the profession in California. They should reflect the diversity of the profession in terms of their background, work settings, path to licensure, etc. This is especially important to have entry-level SMEs who are licensed 5 years or fewer. The first step in developing a valid and reliable examination, whether at the national or state level, is to develop a detailed description of the content to be measured. We do this by conducting the occupational analysis I talked about earlier, and sometimes it can be called a job analysis or practice analysis. And the occupational analysis is a study of the profession designed to identify the most important tasks that licensees must be able to perform safely and competently at the time of their licensure. The results of an occupational analysis provide a detailed description of practice that provide an outline for developing licensure examinations. As you know, professional practice continuously changes, and that includes new research, technology, new methodology, and as a result, testing standards and guidelines require that occupational analyses be updated at regular intervals, typically every 5 years or so. And that's to ensure that the examination stays current with changes in the profession. There are 6 basic steps in an occupational analysis process. It requires the involvement, again, with SMEs of diverse backgrounds, work settings, and experience levels. The SMEs review draft task and knowledge statements, develop content areas, and identify demographic variables. A survey is then sent out to practitioners throughout the state, typically all licensees in the state, if email addresses are available, to determine the frequency at which each task is conducted and how important each task is to professional practice. Once the results of the survey have been received and analyzed, another group of SMEs reviews the survey results and determines the final examination outline, which specifies the weights assigned to the different content areas. Now we will talk about evaluating the validity of national examinations for use in California. Next slide, please. Business and Professions Code Section 139 requires that all examinations, including national examinations, be reviewed in accordance with OPES validation policy. All licensure examinations used for licensure in California must be validated according to accepted technical and professional standards. California practice must be appropriately represented in an occupational analysis that has been conducted at a national level. Next slide, please. A national examination review includes 3 steps. The first step is a psychometric and security evaluation. Next, we use a linkage study evaluating the extent to which competencies identified in California are assessed by the national examination. We call this a linkage study because we ask SMEs to link the content of the national OA with the content of the California OA. During the linkage study, OPES works with SMEs to identify the extent to which the national examination reflects California practice. OPES works with the SMEs to develop a recommendation about California-specific content and works with the board to determine whether a laws and regulations or laws and ethics examination is needed. Next slide, please. During the national exam review, we evaluate the occupational analysis methodology that was used, the examination development procedures, how the passing score is set, how the examination is scored, what the passing rate is currently. We also look at test administration and security procedures, information available to candidates, and the ADA accommodation procedures. Next slide, please. National examinations, by definition, test aspects of practice that apply to all states. If there are areas of practice that vary across states, these will not be covered. Many occupations have California-specific aspects of practice, most commonly laws and ethics, and these will not be covered on a national examination. For licensure examinations, the goal is to measure the full scope of practice in California. We use the results of the California OA to determine whether there are California-specific areas of practice that are not assessed by a national examination. Next slide, please. And that concludes the presentation. Thank you for your attention. I'd be happy to answer questions that you may have.
Thank you for the presentation. Board members, do you have any questions towards Amy? For the process?
I do not, but I do appreciate the overview. It was very helpful. Thank you.
I have a question. In the last comment regarding laws and ethics being an example of California specific, are there other boards that have the situation of a national exam and the missing piece is the laws and ethics? And if so, does continuing education find a balance in there somewhere? How's that handled?
There are quite a few boards that have either laws and regs exams or laws and ethics exams. I think there are some boards that handle it through CEs or continuing education as well. But quite a few have a law and ethics examination or law and regulations.
Thank you. That's very
Mhm.
helpful. Thank you.
So if that's something that was found to be missing, then it might be an option to supplement that through CEs rather than creating a separate laws and ethics exam.
Yes, yes. We would work with you to find the best solution.
I was curious, could you listed on one of the previous slides towards the end some of the things that OPS looks at
Mhm.
in reviewing the national exam? For example, how the test is scored, how passing scores are set. Could you remind me what the other criteria were?
Sure, we look at information available to candidates. So when candidates are signing up to take their exam, is there a handbook with clear information? Is it clear how they register? Is it clear how they get their results? If they need ADA accommodations, is it clear how they can receive those?
Thank you.
Mhm.
I have a question. What does it mean when you say you look at passing rates? What does that mean? Are you looking for a particular, if a test only has 60% passage rate, that's an invalid test? Is that the type of, why look at the passing rate?
We look at passing rates. Typically, we request the previous year, previous 2 years to see, is it low? Is it in the 30s or is it 95? Is it very high? Just to kind of get a general sense of where it is.
And why is that? What is the scientific or fact-based reason that that is significant from the professional, from the group that is tasked with developing tests? Why does it matter whether a test is 95% or 30%? Why should we care? What's the validated
Right.
facts that
Yes.
that suggest to you that's an important consideration?
We want to make sure the test isn't too easy or too hard.
But based upon what? Why?
Psychometrics.
What
psycho-
what does that mean in English?
Statistics. So we look at licensure exams typically fall within a range of 80, which is on the higher side, and sometimes as low as 50. But we look at compared with other professional licensing exams that are similar. So maybe physical therapist, is not just that one, but for an example, some professions, it is just known that the test is very difficult. Is that fair? We want to know if the pass rates are in the 40 and they're always in the 40s. Why is that? Is it more than just how it's always been? Are they working on it? Do they know about it? We want them to kind of tell us a little bit more about why that is. Or if it's 95, why is it so easy? We'll ask questions of the national exam, why it leans on the easier side.
Okay, thank you.
Mhm.
I have a quick follow-up question to that do you look at first-time pass rates or ultimate pass rates? Because in many cases, our OTs take it a few times.
We look at both. Because first time can definitely be different from eventual pass rates. So we look at, that would be something we would take into consideration if first time pass rates are low compared to eventual. That'd be something we would want to get more information from the national exam about.
A similar question. Are you looking at pass rates for all people who take the test or just California test takers?
We request both.
Thank you.
I have a question. Not even sure how to word it. So when you work with the national examination entity, which the name of ours is NBCOT, and I'm not saying ours specifically because I'm assuming you haven't even talked to them at this point, but have you ever had do you ever ask for information that perhaps that entity doesn't want to give? Or have you ever had any problems with that issue?
Typically, no. We enter into an NDA with them. And so before they give us information, we make it clear that the purpose and that we're not going to share it. We understand it's confidential. So we definitely explain all of that and meet with them. And they are welcome to make edits to the NDA as long as legal approves those edits.
So in the past, you've been able to move forward. You've been able to come to an agreement with all other entities. Okay.
Yes.
Okay.
Yep.
Thank you.
And I assume that any of the subject matter experts on all the panels enter into the same NDA agreement?
They sign examination security agreements. Yes. So they would be held to confidentiality. When we do the linkage study where they're reviewing the national exam information, typically that information is not considered confidential. But if the national were to provide something that was confidential, then we would work with them to let the national know, and then also make sure that SMEs understand that they're signing a confidentiality agreement.
Thank you.
I have a question about the test administration procedures. And so I interpret, correct me, please, if I'm wrong, that refers to security in terms of knowing that the right person is testing, that the monitoring and security of the examination environment, et cetera. And a component of that is if they're nationally known testing vendors like Prometrics or Pearson Professional, et cetera, does that help that process along with those known vendors?
Yes, definitely, because many of the national reviews that we've conducted are using those vendors. Yep.
Thank you.
Mhm.
Do we have any questions in the public? David, could we please open it up on the WebEx?
All right, WebEx, now's the time to raise a hand for public comment. If you'd like to do so, tap that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand. And our first request is coming from Cesar Arada. Hold on just a moment, please. We're sending you a request to unmute your microphone.
Good morning.
Good morning. Go ahead, please.
Yes, so I just want to put on record that NBCOT they do all of the psychometric testing that you mentioned, so they would be happy to. I'm sure that information is available, and they would be willing to work with you on that item. It's a whole setup, it's a whole process to create the national exam for OT for everybody to take, and for each state to recognize that. Um, so that's available. Thank you.
Thank you. And that was our only request for public comment.
Thank you very much. So if we don't have any further comments or questions, thank you very much for the presentation, for being here. Greatly appreciate it. Do we need a little break?
Sure.
All right, so it's 10:19. Let's take a quick break until 10:30. Is that enough? Okay, we'll return at 10:30. David, can you please put that on WebEx so others can see it?
As fast as the system will allow me to.
It's there. Thank you. Sorry, don't want to interrupt. We can have a longer break next time. All righty. It's 10:35. Welcome back, everybody. Can we just please reestablish the quorum?
Deanna Marcos.
Here.
Christine Whitlisbach.
Here.
Ada Boone Hurl here. Louis Arabit. Matthew Greco.
Here.
Vicky Santos.
Here.
Aaron Schwer.
Here.
And we have a quorum. Thank you so much. Moving on to agenda number 10, a regulatory update. And I'll hand it over to Austin.
Thank you.
Thank you.
So for agenda item 10, we have our usual, well, not quite our usual regulation package tracker, as well as a memorandum that I wrote to the board. There's some more detailed information in the memo about how things have proceeded from here, but just to give a recap, over the years, the board has approved a number of regulatory language changes. And some of those have been approved as part of a big language change that affects multiple sections. Some of them have been smaller changes that only affect one or two sections. And over time, there have been additional changes that the board has sought to some of the code sections that they had already approved changes for. And it can become a bit of a tricky process to try and make a change on top of a change when the first change hasn't gone through. And so what we have here is an updated version of the tracker that has split out some of those packages that the board has approved in the past in order to what I believe to be the most effective way to capture all those changes and get things moving through the process here. So if we go to the next item after the memo, we'll have the tracker there. And you may notice that this is a little bit more information dense than the previous versions of the tracker that we've had before. But I think it is important to capture all the steps along the way in the regulatory process. And before I get too far into how these have been split up, I did want to take a moment just to introduce the board's regulatory counsel, DP Miller, who has helped me a lot with getting this put together. And since we're going to be talking about a lot of regulatory items coming up in the agenda, just wanted to get her introduced, and I'll let her take it away.
Hi, everyone. I'm DP Miller. I know that I've met most of you already. I joined DCA back in May, and so Austin and I kind of took these new roles together. And I'm a huge fan of the new tracker that you put together. It's much more intuitive to follow and useful to see what's coming down the pipeline and when everything's due. So nice to meet you all. I'm glad. I think I might just stay up here during these items if that's okay.
Yeah,
Makes
I think
sense?
that would
Okay.
probably be preferred.
Great.
Thank you.
Mhm.
So the tracker has all these packages listed out, and we're going to go through them individually. So I won't spend too much time going over each one of the packages here on the tracker. But you can see that we are keeping track of the code sections affected, the description of what the change hopes to accomplish, just in sort of broad terms. And then we have a record of when the board approved that text, when the document for the rulemaking package went to DCA Legal and Budget Office for approval, when they go to the director, and then on to agency, the Office of Administrative Law, when our 45-day comment period is, a record of when the final filing deadline for the rulemaking will occur. The third to final column on here, marked for modified text, will not be applicable in all situations, only if adverse comments are received during the comment period, and we have to modify that text. And then our final filing dates, again, going to the director, to agency, to OAL, and then concluding with adoption and an effective date for the regulatory change. And we have about 3.5 pages of packages here. finally followed at the end by what I have kind of dubbed foreseeable regulatory action, things that language hasn't been drafted or approved or seen by the board and voted on yet, but that are on the horizon for change. So things to keep in our minds as we move forward. And I guess we can go to public comment before we move on to the next agenda item.
Have any board comments so far?
Only that this looks really good and I appreciate all the work that went into this, both of you. Much appreciated and yeah, wonderful. Thanks.
I have a procedural question. If there's something that a prior board has approved, can we still then discuss an item for potential change on it, or does it leave it set as approved?
That's essentially what we're taking a look at today.
Got it.
There are some of the coming items in the meeting that have language that the board approved a number of years ago, and they have not been adopted by OAL yet. And so DP and I have been taking a look at all these regulatory changes and just giving them a third, fourth set of eyes to look at them and see if there's anything that needs to be updated. So that'll be pointed out as we go through. There are some updates to the language in some cases that make it slightly different than what was originally approved by the board.
Thank you.
I'd also like to just note that, even if you approve language today, it is not set in stone as that is the reg until it's approved by OAL and implemented. And so we look at text, you approve it, and then say something comes up in a practice committee and things change, we would bring language back to the board for approval. And you would have a chance to edit it if it feels necessary. And it's certainly wonderful to get it locked down in a way that you feel confident and comfortable with before it goes through the process with OAL. And then again, with the 45-day comment period that Austin mentioned, that's when public has ability to comment. And then after that, the board looks at all of the, staff will look at all the comments. We have to address all of the comments in this final statement of reasons that goes as part of the rulemaking package to OAL. And then as Austin also said, there's a possible opportunity for a 15-day comment period, which is when there is an additional change that might come out of that 45-day comment period. So we heard something, you considered everything, and then you thought this warrants some sort of change. And then you can go up to a 15-day modification period. So there are several, and sometimes there are multiple 15-day. We don't love that. We don't necessarily want that, but sometimes that's what's necessary. So there are lots of spots along the way. But of course, we want to do what we can to get it right in the beginning.
Thank you.
This is legal. I'd like to just add that historically, that's been one of the issues is either staff will discover a problem. And so since we have the reg open, they'll make the changes. It comes back to the board or the board will have an issue. But basically, until it goes to OAL, it's the current board's responsibility to make sure that the reg is what the board feels it should be. Once it goes to OAL, like we discussed, it can be changed, but we have 1 year to adopt. So changes changes have to all go through regulatory process to have comments and whatnot through the public and can delay. But that is one of the reasons why we have so many of these regs open is because if there's a gap of too long and then staff is like, oh, hey, let's go ahead and add this, or the board takes a look at it one more time before we send it. So it's because of all the changes that there's the delay. So absolutely you can change it.
Thank you.
I have one last comment, sorry, for now. As far as timeline goes, the 45-day notice period, the start of that is what kicks off a 1-year ticker. And that's the date by which we have to do a final submission to OAL. So that's until we get to that notice period. Sometimes things can take years or it can take a month or a couple months. But then we're on a clock that OAL imposes. And if we go beyond that 365-day period, then it starts the process again. So you want to get it into OAL within that 1 year after the notice period kicks off. Okay.
Thank you.
Go ahead, Matt.
What does OAL stand for?
I'm so sorry. It's the Office of Administrative Law. So that is the agency that we are going to submit all our regulations to. Once you do, each rulemaking package is assigned an OAL reviewing attorney, and they work with staff and myself they ask questions, we make sure that there's a certain standard that all of our regulations must meet. And so they're the ones looking at it with a discerning eye to say, does this meet it or not?
What are the expectations from OAL that the board should have of OAL in terms of their the speed with which they address the recommended changes? When it's been submitted to them, is it a 45-day? Is it 60 days? Is it how long is it?
They have a 30-day review period for a rulemaking on a regular timeline. And then there's such thing as emergency regulations, which they have a 10-day turnaround, but there are very specific standards that must be met to constitute a true emergency.
Thank you.
Yes.
Can I just request you speak up just a little
Oh,
bit?
I'm sorry. Yes.
Yeah.
There
I
we
think
go.
It's just the air here. You're speaking fine, but it's just.
Yes, I will scoot
Yeah.
closer there.
Thank
I can
you.
hear the difference. Yes.
Thank you. Do we have any public comments? David, can we please open it up on WebEx for public comments? Or questions?
This is the relief moderator. If anyone is there any public comment in the room on this topic?
Oh, none here.
Thank you. And if anyone on WebEx would like to make a comment, you may look for the hand icon, typically at the bottom side of your screen if you are on a computer. If you're on a mobile device, that public comment hand raise might be behind the 3-dot other options, and any calling users can press *3 to raise their hand. Are there any comments on this issue? I do not see any hands raised. I can turn the meeting back to you.
Thank you, moderator.
You're welcome.
Okay, so what would you like to proceed with?
We don't need a vote or anything on this item. We can move on to 11 if there's no more discussion.
Good to go. All right, we're going to move on to agenda number 11, discussion and possible action to consider initiation of a rulemaking to amend section 4101 of Title 16 of the California Code of Regulations, delegation of certain functions.
May I?
Yes, please. Trying to get there.
All right. So I'll just provide a brief overview of some of the information contained in the memo here. But the last time that the board looked at this code section was in November of 2024 at their meeting. And what this change has to do with is, well, let me back up a little bit. There is a Business and Professions Code, section 820, that gives the board the power to order an examination, a mental or physical examination of a licensee whenever it appears that they may be unable to practice safely. And as part of the board's regulations, that power has been delegated to the executive officer so that the executive officer can order that mental or physical health examination in order to prevent any prior knowledge issues of a potential disciplinary case. If board members were to have prior knowledge of something like this going on, they may or may not have to recuse themselves from a disciplinary action decision. There is an additional code section in our regulations, section 4148, that establishes that the board may order a similar type of examination for an applicant. So that authority is not under Business and Profession Code section 820, but it is under our regulations, section 4148. However, back in 2024, it became apparent that the term "the board," as used in the regulation, was somewhat ambiguous. It wasn't clear whether or not that meant the actual board members, the board president, the board staff. And so the issue at hand that day was to get this power also delegated to the executive officer. The minutes that are included here detail the discussion that was had that day. It was fairly straightforward. Our legal counsel, Helen, was there, so she can provide any background if anyone has some questions about the logic behind this change. But the language that they had decided on was altering California Code of Regulations, Section 4101, which deals with the delegation of certain functions to the executive officer. So this includes that delegation of Section 820, the licensee examination, as well as other powers that are delegated to the executive officer. And in that section, the board had elected to add the applicant examination to the list of delegated powers. In addition to that, they approved language that modified Section 4148, which is the section that gives the board this power to order the examination, to instead give that power to the executive officer. So our purpose here is to, one, get an updated motion with a good, clear motion to pursue the rulemaking, but also it may not be necessary to make both of those changes. In fact, the change in Section 4148 by striking the word board and replacing it with executive officer does give that power to the executive officer, but it also strips the board of that power. So it may be best to simply leave Section 4148 alone and then delegate it in Section 4101, so that should the board ever need to, although this shouldn't happen ideally, they do still have that power to order the examination. And that will make a little bit more sense looking at the suggested language.
If I may, one of the reasons we changed the 4148 is that it says board with a small b. And typically that means staff and not the board itself. And then that was confusing. But one of the reasons we had it in 4148 is the board itself cannot see any applicant items at all. So it's nonsensical to have board and mean the board. And so that was one of the reasons we developed this, and also one of the requirements that a deputy attorney general required in order to allow the executive officer to fulfill this duty.
Oh, I'm sorry, could you share more about the Deputy Attorney General's request?
We had, if I remember correctly, we had a request for this to happen to an applicant. If I remember right, the applicant refused, and so we did a statement of issues, and the DAG refused to follow or declined to prosecute because it looked like the board had to do it, which is, again, nonsensical throughout DCA. The board actually has to handle the final decision of the SOI, and staff is consistently handling the application itself and following the law as it is. So because the DAG did not want to follow through with the SOI, we had to make this clear. And luckily, we don't use this very often, but in the one time we needed it, is they said that it was unclear, and if the executive officer had the power, it had to say the executive officer. So I don't know if there was a disconnect with the DAG versus the language, but the small b has always been assumed, and that's how it was adopted in the reg back in the day.
Right. So that being said, though, is there, whether it happens in 4101 or 4148, is there a need to make both changes?
Our analysis at the time was that it is. Even if it's duplicative, I don't see the harm in it, but I will defer to our reg counsel. But that was what we had determined at the time, to make sure that they made sense together. And so that, but at minimum, the 4148 should maintain executive officer. And if there is no executive officer and interim executive officer, there's all types of substitutes for that position, that it would never come to the board. It would always remain with staff.
Okay. I have no problem doing it in both spots, and we can do it as a single rulemaking package. Just a question for you, Helen. So when as it's written with board little b, Is there anyone else other than an executive officer or whoever is filling in if the executive officer is unavailable for whatever reason that would ever fulfill 4148?
Generally, staff, if I understand correctly, staff handles the analysis, but then the final signature, much like a proposed decision or an SOI, goes to the executive officer. And so whomever is filling that role, whether it is, as we had earlier, an interim executive officer, or there is a whole process of delegation, it would be that person who is in charge of the staff on behalf of the board that would sign that.
Okay.
So, and that should be clear in other regs that executive officer or, in case of not an executive officer interim, but it would not necessarily be a designee. So not necessarily the chief of enforcement. It would still be the executive officer, whomever is filling that top role.
Okay, so to change it to executive officer would not preclude anybody else from doing it. That's what I want to make sure that, right, okay. Austin, what do you think here? I'm fine with that.
If it's not harmful and we think there's some benefit to doing it in both places, we can certainly do that. I'm just wondering about getting a motion. The language that we had here presented for board vote dealt only with section 4101.
So when the motion is read, you can include and 4148 as discussed and amended during the meeting.
Okay. The 4101 language that is presented at the end of this item is slightly different than what appeared non-substantively than what appeared in 2024, just a little bit more descriptive about what code section is being referred to. Is there any changes that should be made in 4148 other than just inserting executive officer in place of board? Is there any reason to have anything more descriptive than just executive officer?
It should not be necessary.
Okay. Look at this language.
I just have a question. If we add executive officer, does that remove the board to be like losing our, position or like input?
So this is what Austin and I had been discussing, but now hearing context from Helen and what the DAG said, and that in fact the board doesn't have that. My understanding from you, Helen, is that the board, big B, you guys don't have the ability to order this, and it was actually the staff, little b board. So I think that authority was not with you to begin with, and so it's not being taken away. Yeah, yeah.
Thank you. Anybody questions, concerns?
I have a couple of questions. One, there was a abbreviation that was used, SOI. What does that mean?
I do apologize. SOI stands for Statement of Issues. So an accusation is what is issued when a licensee creates an error. An SOI, Statement of Issues, is when an applicant is being denied their license. So they are still entitled to due process to appeal that, and then that's done through a document that's called SOI rather than an accusation.
And can someone give us a sense of whether this is a solution in search of a problem or whether this is a real problem? We have a single example that you've referenced where a DAG, a deputy attorney general, was unwilling to move forward and require this examination because of some failing. And so besides that single instance, has this ever been used at any point, if the executive officer knows? Do you know?
To my knowledge, in the last at least 4 or 5 years, that was the first time that it came up and that it was an issue.
Has it ever,
So
Council?
from what I understand, this came up under our previous executive officer. And one of the reasons the law was made to begin with was to codify the process that's set forth in 820 regarding each board's responsibility to take steps to make sure all licensees are psychologically and is it physically, but basically able to perform the license process. And if they are unable to do so, or the board feels like there is a concern, before we license this person, we have to make sure they meet those qualifications, and the law has allowed for healthcare professionals to do that. And so one of the issues is it's a huge problem if we don't have it when we need it, which is exactly what we found out, is that we desperately needed to make sure that this applicant was appropriate for licensure. And then we were unable to ensure that, or at the very least, unable to deny the license through that process alone, which under the statute is permitted. So it's one of those things where hopefully applicants aren't applying when they have a inability to perform, but it is the law's intention that we have that ability to make sure that they are able to perform before we license them.
So just to be clear, the board has the responsibility under the statute to make sure that an applicant who has a mental disorder that would impact their ability to be a therapist does not get licensed. And yet, we also are prohibited from having any direct access to that applicant. Is that correct?
It is, and that's because the board has to remain separate in case of dispute. So when a statement of issues, or when someone appeals the license denial, it goes to a statement of issues, which goes before an ALJ, which is administrative law judge, and the matter is heard and making sure that all due process is established. And then the board reviews that decision and approves or denies it, or, goes through the whole process. But because the board is the ultimate judge in that decision, it's one of the circumstances where staff follows the law. The board can adopt law and regulations to make sure staff is doing what it needs to do. But it's separate because ultimately the board may have to make the decision of whether or not this particular person needs to be licensed.
Where is it in either of these regulations how the executive officer is to use this delegated authority? How do they make that determination? What are the standards that they're applying if this is an authority that we are delegating to them? Number one, what are their standards? And number two, under this regimen, do they have an obligation to come and inform the board that they're using this authority and to seek our approval to use that authority? Or is it, do they have that authority just by basis of this, and they have the ability to use their own standards in terms of, or what standard do they use to apply whether or not they need this?
So this is a law that's special for healthcare professionals. So non-healthcare professionals do not have these provisions. They should be set forth in 800 et sec. I don't remember exactly where, but yes, they cannot come to the board for this because of due process. The board itself serves as the judge. And so if there is a problem, that's where due process comes in, and it goes through the administrative process, and it's handled by an ALJ who takes all appropriate evidence. And then the board has to make that final decision. So staff can never come before the board to handle that. It has to go through the due process procedure to allow the other party to be heard.
And Austin, where would you go to determine whether or not you should use this authority? That's what I'm trying to figure out, was how do you know whether to use that authority?
So the language as written is fairly open-ended. If I can bring it up here, I believe it says, has reason to believe that the licensee or applicant may not be able to practice safely. So that's fairly open-ended. There are no strict requirements or criteria set forth that need to be evaluated. However, this authority is not to deny an applicant. That authority already exists for the board staff that can deny an applicant. This is simply the authority to order the examination. And then pending the results of that examination could make the the determination of whether or not the applicant would be denied or the licensee would be subject to discipline. So really I guess I would say the safeguard in terms of whether or not the executive officer or the board staff would be overextending themselves would be the evaluation of the medical professional that does the exam and their recommendation following.
The statute 820, that is from where we get the authority to promulgate these regs, it is similarly vague whenever it appears. So I have not seen, and Helen, please correct me if I'm wrong, but specific standards of what would lead one to believe or it appear that it's needed.
I am checking, but I do believe it's intentionally vague. The board staff has to have a doubt, but you don't want to make it so limited that you could potentially be forced to license someone who's inappropriate to be licensed. So they have that. Let's see.
Just not as a specific example, but maybe a more general one. Somebody may indicate on their application for licensure that they have a health issue, either mental or physical. And it's a little bit harder to sort of organically come across that information for a licensee. Typically, we're not receiving any sort of notification about that for a licensee unless it's connected in some way to conviction of a crime. But for an applicant, most often it would be something that they indicated on their application, that they may have mental or physical health issues that may prevent them from practicing safely.
It may also be in any discussion they have while investigating the application. I do know of an example where we had someone who wanted to reinstate their license. I do believe that was a different board, but they wanted to reinstate their license, and it was not a healthcare board, so they did not have that option. But this person was known to be inappropriate for licensure due to dementia, severe dementia. And it was very obvious to staff every time this person called, but also we contacted his family members. But essentially, we made regulatory changes to at least require that CEs had to be submitted prior to relicensure. He had gone into retired status to try and weed that out. But that is one of the things, that's one of the reasons why 820 applies to all, 820 EdSec applies to all the healthcare entities to avoid having that type of situation. But if someone either indicates or has on their license, basically it says if we feel they do not, there may be unable to practice, we have the power to double check.
Well, along those lines, I mean, what if an individual is requesting ADA or requested ADA compliance for taking a test? Does that information come before you in their application? And if they do, and they say they're making that request and they define why, for instance, they have PTSD, they have some mental disorder, caffeine addiction disorder, bereavement disorder, whatever, or a substance use disorder, is that considered when, can you use that type of, is that the information that you're referring to? Or are you referring to something else?
An ADA request for something like taking an exam we wouldn't be privy to that knowledge, especially since the exam is administered at the national level, but it's self-disclosure on the application. There's a question that asks if they have any mental or physical impairments that may affect their ability to practice, and it's voluntary to, well, they sign under perjury that they're being honest there.
Okay.
Of course. Thank you.
So I guess we need a motion, right?
I just have a clarification. So we actually, as a board, don't have the authority to order this to someone to undergo a mental or physical examination, right?
Or
Not
an
at,
applicant.
not at the applicant stage. it could be, just to make things more confusing, at the SOI stage,
Mhm.
the board may be able to include that if we went through a whole process, or omit it if the ALJ said it had to come in.
Okay.
But essentially, the board has never had this ability because they have to be held separate in case there is a dispute.
Mhm.
And the staff applies the detailed law that's in there.
Mhm.
But this is a power that's granted for all. It's just a matter of carrying it out, and nowhere does the board have that power because they have to remain separate.
Right. So the board that was being asked here is only the staff that makes that decision for that
Correct.
applicant, right? And now what we're fighting is that the executive officer be the one to make that decision.
Correct.
Yeah.
Yeah, so this is what we determined to be a relatively easy reg, because it's known, although making it executive officer does make it clearer, that small
Yeah.
b means staff, big B means the board,
Got it.
when there's a division of powers. Otherwise, it's all the board, and so in this particular sense, it's nonsensical because the board would never look at the applicant's documents
Mhm.
without first going through an ALJ for a due process hearing. So that's why it was a shock that the small b didn't work. And so this just makes it clear.
Okay. Thank you for the clarification.
I would like to add, just in the general discussion of reg items before us today, part of the reason a lot of these are coming back is to get a good, clean motion. So if anyone were inclined to make a motion, there is a suggested motion at the end of the memo. It's quite long.
Oh, let's go to public comment just in case, right? It's always a good.
You may want to take a motion in a second before we take
Oh,
public comment.
Oh,
Otherwise, we'll have to do it
any
again.
questions towards any of this?
Okay.
Well, it's up to you.
Well, I mean, it's up to you.
It's up to you.
Any time is a good time for public comment, but you
Yeah,
still are required to take public comment after the motion, and you can always withdraw, but you are absolutely welcome to do so.
Well, I just feel like, okay, okay, let's hear the motion then.
I move to approve the proposed regulatory text for section 4101 and 4148 as amended, and to direct staff to submit the text to the Director of the Department of Consumer Affairs and the Business Consumer Services and Housing Agency for review. And if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for a hearing if requested. If hearing is requested, authorize the executive officer to take all steps necessary to complete the rulemaking and adopt the proposed regulation at section 4101 and 4108, Title 16,
The last part, 4101 and 4148.
4148 and 4101 of Title 16,
Mhm.
California Code of Regulations as noticed, with the authority to make any technical or non-substantive changes.
That was great.
Can we have a second, please?
Second it.
So much easier.
I love it. Do we have any further board discussion? Okay, can we please open it up to public comment on WebEx? Oh,
All right, WebEx, now's the time to raise your hand if you would like to make a comment on agenda item 11 or the motion. You can do that by tapping the hand button at the bottom of the screen. Dial-in users dial *3. And our first request is coming from Cesar Arara. Hold on just a moment, please. We're sending you a request to unmute your microphone.
Hello.
Hello, go ahead, please.
Yes, so I'd just like to make a public comment about this. Mental health is um, wide variety, right? And all encompassing and across the lifespan. So occupational therapy works with people with mental health, and we recruit students and practitioners to reflect, to be able to serve our clients, and be able to have that background to also to treat them. Um, and we want diverse OT population to be able to service the needs of our clients, which may mean that our OT practitioners will have mental health diagnosis. Um, and it's my hunch that this is underreported because of the stigma already that's attached. So, well, although it says, do you have mental health that impairs you, they will not report that, right, on their application. But I think this might be, I just want to put on record that it might be an overreach because there are institutional things in place in organizations. They will not hire, or well, that person might be under disciplinary action. Um, I, I think it's unnecessary, personally. It just doesn't reflect what OT is. And we pride ourselves by being able to look at the person wholly, physically and mentally. And so this seemed to really um, be against the basic tenets of occupational therapy. Thank you.
So I'm going to respond to that. So I do appreciate the comment because, what you're saying is that we do want practitioners from all walks of life to be representative of the clients that we serve. That is true. I think that the intent here is not to preclude practitioners with mental health issues from practicing. The, the diagnosis itself, or having the condition itself, is not the issue. The issue is, does it interfere with your ability to practice? And that's where this particular um, language comes in. So we would, if in dealing with this applicant, there seem to be issues or there seem to be problems, you got to sense that the condition may be interfering with this client's ability to practice safely. That's when this would kick in. And I don't know if Helen, you want
So
to say.
Right. So is that the board's decision to, or the institution or the primary physician and that person to
So to
determine
clarify,
that?
the scope of this regulation is simply to clarify that little b means staff. That's the entirety of this regulation. The ability for a healthcare entity to determine whether or not someone is psychologically or physically able to perform the duties of a licensee is a statute that applies to all, and we have no control over that. That is just an option that the healthcare entities have. And then, of course, because it's subject to due process, a simple stutter would not pass due process. And so it would not be something that would prohibit someone from being able to work. Um, controlled schizophrenia or whatever. If something is under control and it does not appear that this person is unable to function, then that would also not be a basis. But it allows us to make sure that we are not licensing someone who is incapable of actually performing the duties of a healthcare profession, in this case here. But I did want to clarify, the whole scope of this reg is strictly to clarify that little b means executive officer.
Yeah, I think his concern though was beyond that.
Yeah, I know, but I was
Yeah,
like,
yeah.
that's not quite on the agenda. And also, I understand it's wrapped in, but I just wanted to make that clear. The whole point of this reg is to clarify that point.
Okay. Thank you. Well, it just seems like I think we have an existing reporting system that can take care of that, is what I think. The reporting that somebody is on an active psychosis and unable to pursue, and coworkers and institution or public can report that to the board, and then that will determine the process further. I mean, for investigation. Thank you.
If I could maybe help try to alleviate some of that concern, I, I don't see a lot of situations where this would be the single determining factor in whether or not an applicant was denied licensure. And as Helen had mentioned, this is all subject to due process. So the examination may be ordered, the physician or mental health professional would make a recommendation about whether or not this affects their ability to practice. Then there is the statement of issues that goes to the deputy attorney or comes from the deputy attorney general, and an administrative law judge would issue a proposed decision that would then go to the board to make a decision about. So there are plenty of steps along the way to ensure that board staff, meaning myself or some designee of mine on board staff, cannot flat and outright deny a licensee or an applicant licensure based off of a mental or physical health condition.
Thank you, Cesar, and thank you, Austin, for clarifying that. Do we have any other comments on WebEx? Public comments?
There are no other requests for public comment.
Thank you so much, David. So, okay, let's take a vote, please.
Beata Marcos,
Yes.
Christine Whitlisbach,
Yes.
Ada Boone Hurl, yes. Louis Arabet,
Yes.
Matthew Greco,
Yes.
Vicky Santos,
Yes.
Aaron Schwer.
Yes. Okay, motion carries. Great job. Nothing got lost in translation. All right, so we're gonna move on. We're gonna move on to agenda number 12, discussion and possible action to consider initiation of rulemaking to add section 4110.1, application at the station, and 4122, renewal at the station, to Title 16 of the CCR.
Very similarly to our last agenda item, we're going to be taking a look at something that the board has discussed previously. Some veteran members of the board may be surprised to see this before them again today, but it's important that we get it right before it goes and gets adopted by OAL. This regulatory package has to deal with something that was actually brought up earlier today, an attestation that applicants make and licensees make at the time of renewal regarding their understanding and comprehension of the California laws and regulations surrounding the practice of occupational therapy. So the last time the board took a look at this was in August of 2022, and they had devised an approved language to add a couple of sections, namely 4110.1 and 4122. Those have to deal with an attestation for applicants and an attestation for licensees at renewal, respectively. And this was originally approved as part of a much larger package that is being broken apart to capture some additional changes that were requested in other code sections that were originally included there. However, since we are bringing it back, Regulatory Council and I have taken a look at the language and have come up with some edits that we feel might make this a little bit more clear. So that is the final thing at this agenda item. You can see proposed language for 4110 and 4122. The main concern that we had discussed was whether or not these need to be new sections or simply amendments to existing sections. Unfortunately, I don't have 4110 and 4120 in front of us, but we may be able to pull that up. Let me see. I just wanted to ask the moderator, is it possible for me to share my screen? I believe I'm in
Absolutely.
the meeting.
Yes, at the very bottom of your screen, you should see a share button. Your first tab will allow you to share a screen. Second tab will allow you to share a file that we've uploaded.
Thank you. All right, so on the screen before everyone, we have section 4110, application for licensure. This is the section that goes over what is required for an application for licensure. The original proposed language was to add a section following this, 4110.1, that implemented the requirement for the attestation. And per my discussion with Reg Council yesterday, I believe we landed that this may be able to just be added to 4110.
Yeah, I think either way, but we were talking about adding it as subsection D to 4110. The language would stay the same. We didn't have any edits to that. I have one very minor non-substantive edit to the first sentence of the language. After notification that the application for licensure is complete and accepted for filing, I wanted to add a comma there to just make it very clear that it's after the application is put in, but before a license is actually issued. That's the only edit I had.
And to be clear, this attestation would not be part of the application process. Rather, applicant would fill out their application, pay their application fee, board staff would review their application and documentation. And then once they are approved for licensure, applicants need to log on and make an initial license payment, which then grants them their license number. So it would be at that point in time where they made this attestation.
Oh, so you wanted to
I
make.
thought you were unmuting to ask a question. Okay, if there's no questions regarding section 4110, as an additional subsection rather than a new code section, we can move on to 4122. 4122 is a similar thing just for licensees at the time of renewal, and it was originally suggested to be added after section 4120, which deals with the renewal of license and the forms that will be used to do that. DP, can you remind me, did we land on adding that in?
Right, we talked about adding it as 4120 A2 to the end of A2 that exists right now. So that 4120 is what Austin is sharing from his screen right now. And little a subsection 2 starts with to renew an unexpired license, the holder shall, and it gives the various steps, including that they must certify that their representations on the renewal form are true, correct, and contain no material omissions of fact, signed under penalty of perjury. And we were talking about just adding this that is before you as 4122 to the end of that subsection. Seemed to make most sense there. The one other thing we had discussed was under A2,
Yes.
we would add this language at the end of 2, and because we are amending the subsection 2, we would take the opportunity to strike the word unexpired. So right now it says to renew an unexpired license, the holder shall, and we wanted to simplify it and say license, because for another date and time, the word unexpired is used in various ways in the regs, and we will address that once we have a more comprehensive look at it. But for now, I think this is the
Yeah.
cleanest way to do it.
We wanted to be clear that this applies to any license renewal, regardless of what status that license may be in prior to renewal.
I'd just like to say that I appreciate the clarity of this. For the reader, that when things are repetitive and upfront, they tend to register better. And so I appreciate these changes and the clarification of the unexpired. It just is a license. Yes, thank you.
Thank you. When looking at the materials that were provided, I just want to clarify that where it shows language has been underlined, there's a typo, section 4101.1. It's going to be 4110 subdivision D, just for purposes of our motion.
All right. Any further discussion? Then could we make a motion, please?
All right. I move to approve the proposed regulatory text for sections 4110B and 4122 subsec 4120
Yep, A2.
A2. Okay, I thought I had that. All right. As amended during the meeting, to direct staff to submit the text to the Director of the Department of Consumer Affairs and the Business, Consumer Services, and Housing Agency for review. And if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for a hearing if requested. If no adverse comments are received during the 45-day comment period and no hearing is requested, authorize the executive officer to take all steps necessary to complete the rulemaking and to adopt the proposed regulations at section 4110D and 4120A2 of Title 16, California Code of Regulations, as noticed, with the authority to make any technical or non-substantive changes.
Thank you.
Do we have a second?
I second.
All right, thank you for that. Do we have any further board discussion? Do we have any public comments? Oh, sorry.
Sorry, just for purposes of the minutes, can we just note that these sections were presented with the numbers that are listed in the meeting materials, 4110.1 and 4122, and that per our discussion, we decided to move them to more appropriate sections. So
Yes.
it's not in the
I
motion.
appreciate that.
Thank you. Very nitpicky.
Thank you, DP.
I have a comment on 4110. If you look at the State Practice Act again, there is an association that no longer exists. So if you could put that back up, please.
Would you like me to pull up the language that's proposed here for 41 10, or would you like
4110,
the section of the Practice Act that you're referring to?
the section of the Practice Act?
Okay,
please.
I think I know what you're referring to. Let me find that. And I believe it's mentioned alongside NBCOT. So let me
Yeah,
try and find it that way.
exactly. Because that's the AOTCB. That is an old name of the NBCOT.
And that is correct. That is correct that it is an old designation and no longer exists. However, that came up in prior meetings because there are still practitioners that are that were certified, registered under the old organization. So at that time, that's why it was left there. I was not on the board at that time, but I do recall that being in discussion as a public observer.
Sorry, I was looking for that here. Luis, were you referring to the American Occupational Therapy Certification Board? Is that the organization? Okay. They appear here in 2570.6 C2, and they may appear elsewhere. Yeah, again in 2570.7. And I believe that's it, those two places. So is the issue that we're requesting people to read and understand and agree to abide by these laws when the law is a little bit out of date?
I don't consider it to be out of date with the AOTCB there because there are still practitioners who were initially certified under that agency. So even though the agency doesn't exist anymore, it just gives language that captures the state of the profession at the time certain practitioners were certified.
Absolutely.
So I think that's why it's still there. You know, we get a little further down the road and could consider removing it, but I don't know that we're quite there yet.
Sure. I don't think it hurts to have it. I don't think it's
Right.
impacting anything negatively.
That's a good point, Ada. Thank you.
Do we have any, do we need to go to public comment again?
Yeah, because we haven't done it yet, right?
Oh, sorry, not again.
Oh.
For
Do
the
we have
first time.
Public comment? Oh, sorry. Do we have any public comment? How about WebEx?
All right, WebEx, we have, if you'd like to make a comment on agenda item 12 or the motion, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few more seconds to see if we have a request for public comment.
In the interim, I just wanted to let you know, when you take roll, it looks like
Oh, she's
Member
gone. Yes.
Vicky has lost, I don't know her last name, I'm sorry, has lost connectivity for now. I do believe we're trying to get her back on, but.
No,
Can we take the roll?
no, she's done.
Oh, then my error.
Yeah.
But either way, she's no longer on there.
Yeah.
So do I still call and say absent?
Yep.
Thank you.
There are no requests for public comment at the moment.
All right, let's take a vote, please.
Beata Marcos,
Yes.
Christine Whitlisbach,
Yes.
Ada Boone Hurl, yes. Louis Arabit.
Yes.
Matthew Greco.
Yes.
Vicky Santos, absent. Aaron Schwer.
Yes.
Okay, motion carries. Just for a second here, we need to regroup on lunch because the hearing starts at 1:30. So let's say if we go to lunch at 12:30, we can pause now for 5 minutes to place orders and maybe somebody can go pick it up. So we're not all driving there. Like, so can we take a 5-minute break? Please?
You're the president.
Yeah, we're going to 5-minute break. Okay, we'll return at, let's say 11:45, so 7 minutes. Our apologies, we had a little bit of a delay, but we're starting the meeting again. We're moving on to agenda number 13, discussion and possible action to consider initiation of a rulemaking amend section 4102 of Title 16 of the CCR, changes of address and change of name. We have an overview, right? A little bit.
We need to reestablish quorum for the very, very.
Yeah.
We only had a minimum.
Yeah.
Oh, you know what? We should actually.
No,
note
because she's
that-
not, okay, I apologize. Let's just reestablish the quorum, please.
Beata Marcos.
Here.
Christine Whitlisbach.
Here.
Boone Hurl here. Louis Arabet.
Here.
Matthew Greco.
Here.
Vicky Santos absent. Aaron Schwer.
Here. And we have a quorum. So moving on to agenda number 13.
This agenda item deals with proposed changes to regulations code section 4102. That has to deal with change of address requirements and change in name requirements. This was last before the board in August of 2023. Again, part of a much larger package that additional changes are being sought to for some of the other sections here. So the main reason this is before us today is to get a motion for a separate package for just this 4102 section. Originally, this language is being looked at to clarify the difference between what an address of record is and the requirements for keeping it updated with the board and what we use it for, and similar requirements for a residence address. What are the differences between the two? What's required to be updated? There were also some changes to or requirements implemented for keeping the board advised of any name changes and providing the board with an email address should a licensee or applicant have one to provide. So following the meeting minutes, we have the language that was presented in August of 2023. And then following that, we have the language that is for vote today. The language here, I don't believe it does not have any changes from what was presented in 2023. This is really just brought before us today to get a motion for a separate rulemaking that didn't include all those other code sections. However, I think we may have some board discussion.
That's the board discussion.
I'd like to go ahead and jump in on that discussion. I was frankly quite surprised when I read some of this information, recalling the discussions that were had at the board, by the board many years ago about the publishing of a practitioner's address. And at that time, I, as a public member, had expressed my concern about the public distribution effectively of a practitioner's address, in that we had just had a physical therapist murdered by domestic violence because the husband had found the public address. And it was through that argument that the board discussed that we will not publish the address at that time. We now live in a more complicated world, and I have great reservation about publishing the address. We have mental health issues as a community. We have identity theft, a variety of different aspects, and I'm not sure what might have triggered the need to publish the address when we have sufficiently not done so for so many years. The other thought about that is that's about the publishing. And then I needed some little explanation, please, regarding the residence versus location, because I'm confused. And if I'm confused, then the public may become confused in one of the major items that causes citations for the license. So I think there was, I had one more note. No, those are my concerns at this stage. Thanks so much.
Thank you. So let's just start by addressing the publishing of the addresses. To my knowledge, the board itself does not publish these addresses on its website anywhere or make them available to the public. They are available, published to the public upon request. There's a request that you have to make from DCA's website. I believe that's part of a broader business and professions code that's outside of our Practice Act for all licensure boards, that those addresses are available that way. So that is not something that we have control over, whether or not those addresses are accessible to the public that way. The language here, I believe, is beneficial, just that it makes it clear that, hey, whatever you put here, there's going to be a way for people to access it. So I think it's better to have it in here so that people are aware, because we can't stop it from being available.
May I ask a clarifying at this stage? Because when you go check a license on the DCA website, it does not state an address. It says address not published or whatever. So where is it that people would find the address?
I'll try and bring that up, but it is a separate page. It's not the license verification, and it's actually provided in a Excel spreadsheet. It's not just a single licensee piecemeal. You can go on there and you can download a a table of all licensees for not just our board, but for other boards as well. So I'll see if I can pull up the example of what that actually looks like. I'll see if I can track it down, but it's not something that we publish on our website and make available through any act of our own.
It's through the Breeze system? It's through the Breeze system, that Excel spreadsheet? Is that what you're saying?
I think
Austin?
it's done on DCA's website.
Well, are you talking about Breeze when you say DCA's website? Or what do you, oh, he's talking to Helen. I can't see.
Yeah, sorry.
Okay.
When the DCA website that I'm looking at, where I see that there's no reference to address, is
Talking about Breeze.
under, well, not Breeze. I go to the Board of OT and then I click verify a license.
That's Breeze.
Thank you for clarifying
yeah,
that to me. I didn't realize that.
Motion says it's not
What I'm
Breeze.
talking about.
So there's another place.
No, it's not through Breeze. It is a .ca.gov address. I'm not sorry. It's not on Breeze. It's some .ca.gov web address that I'm trying to track down right now. I have had to use it once or twice before, because it had to do with email addresses, but it also includes the physical address. But it's not through Breeze, although we do have the board staff have access to people's addresses through Breeze, but that's not available to the public. This is a different tool.
So if I could be hopefully helpful, Business and Professions Code 27 requires that there's a business, address of record placed on the website. So the public must have access to an address of record. That address of record can be a PO box. It can also be an address that is provided by the state for people who are victims that need a separate address, where basically you mail it to that address and then the state will then mail it to you. So it doesn't have to be your actual location if there's a safety concern, but there has to be a method of location. Typically, the address of record is whatever your business address is. And then internally, we have a mailing address or a private address that is not disclosed at all, except by court order.
And that's the address, not the address of record, but the address of.
Residents.
It could be your address of residence,
you,
yes.
thank you.
So if you wanted a separate mailing address, but you just didn't want it public, then that could be the address. We are required to serve any documents to the address of record. So it has to be a good address of record. We're actually not required to sending it to the mailing address. However, we typically do additionally serve it to the mailing address. But if there is a better address to reach you at or an email address, we can do that internally although I can't remember if this is asking for an email to be public. Most emails throughout DCA are codified as not public. Then that does not go on the public website. But this is something that applies DCA wide.
Another clarifying question. So I think what I just heard is that instead of an address of record, it could be an email address of record.
No, it has to
Okay.
be an actual mailing address. But if, for example, a licensee provided us with an email, we would not publish that.
So to protect your residence address, where you live, you have to go and get a PO box and pay the money for the PO box.
Oh,
Then I'm still confused. So
Okay,
thanks
most
for your
people
patience.
typically use where they work. A lot of places are already public as to where you work, or you work at a hospital, so it goes to the hospital. So typically, the address of record is your business address or something you've already made public. If you do not wish to use, if you do not have that option, let's say you work outside of your home, then your choices are to publish your home address or to publish an alternative address, such as a PO box, or in the case of, I do not know the qualifications, the state address for people who are victims. But we are required to have an address of record for every licensee by law that applies to all DCA entities.
So then my other clarifying question is, because this is all underlined, this is new text that's being added, right? So
Correct.
why do we need to add it?
The requirement to provide an address of record and the fact that it's available publicly is not changing as a result of the language here. The language here aims to clarify what the difference between an address of record and a residence address is and what the board uses to contact a licensee or applicant. The main reason this even came about is because what the biggest number one violation, the leading violation for licensees at the board is failing to update an address of record. And that is important because if you don't do that and something more serious were to happen, we can't contact you. You don't know that we're trying to get in touch with you. And next thing you know, you have an accusation and you're facing disciplinary action just because you didn't update your address. So the point of these address of record, the new proposed subsection A and subsection B, is really to clarify what the address of record is used for, that it can or cannot be your residence address. You can provide an alternate residence address so that licensees and applicants understand what information they need to provide when their address changes. But as it stands today, if this change isn't adopted, licensees and applicants are still required to provide an address of record. It's available to the public right now as we speak. And if this language were implemented, that would still be the case.
And if you get when you have both addresses, right? Because one of them you have to update it. Well, if you change it, you have to submit it within 30 days. Do you have to do it with this residence address as well?
So you're not required to provide a updated residence address. You're required to provide an updated address of record. That could be your residence address, or it could be an alternate address of record. But regardless of which one, 30 days.
Correct.
And-
The mandate for the address of record is required to be updated because that is the official way that any kind of due process or required documents are sent. So if it's not updated, it is the fault of the licensee and not the fault of the board for being unable to provide an accusation or citation to that party. It was their responsibility to uphold the correct address of record. And also it's a public safety concern, which is why the address has to be posted at all so that the public can reach out to this person. We do not provide phone number. We do not provide email. So a hard copy letter or physical appearance would be the only way that a public member could reach that licensee. So that is why that particular one has to be updated. If you do not wish to update your internal mailing address, it just goes to that address. It doesn't, but that is, or you can correct it. But the address of record is mandated to be updated for due process purposes.
Can I clarify something? As currently written, the residence address is also to be updated within 30 days. So if that is not our intention, we should strike that sentence.
My mistake.
Okay. Oh, no, that's okay. So this is great. It's good that you asked all these questions. So we will strike it. And I also want to just clarify real quick. So as 4102 is currently drafted, it does reference to the ability to put forth two different addresses. But as currently written, if you did do two addresses, one of record, one of residence, you have to ask in writing for the residence address to remain confidential. As written now, which I think will is a benefit and more aligned with what you were talking about, if you provide two and your residence address is a separate and different address than the address of record, it will automatically remain confidential by the board. So that I think is in line with what you're hoping for, and I think it makes sense. Does that make sense?
That part makes sense and that's helpful. And I lost what you said in the first part.
And the first part, I was responding to Austin where we were talking about that we don't actually, that a licensee doesn't need to update any change of residence address within 30 days. But our text actually says we do, but we don't want that. So I'm going to strike that. So it'll be address of record does need to be updated within 30 days of any change. Residence address does not need to be updated within 30 days. Is
President,
that
can we
right?
please take a 2-minute break?
Hmm?
Can we please take a 2-minute break?
Sure.
Thank you.
Let's go to a 2-minute break, please. Moderator, thank you.
It is currently, so I'm fine with that, but I guess it's to the board.
The board can opt.
Shall update, you mean the? I mean, it says as written here,
Mhm.
shall provide.
Well, yeah, because otherwise if they want to contact, exactly.
Yeah,
Oh,
I mean, the way it should ideally work in practice is that you give us a residence address. You don't give us any other address, that is also your address of record. So I don't want to imply that, I don't think we should imply that there's a circumstance where you don't have to update your residence address, because for many people, that will also be their address of record.
can we reopen the meeting, please? Okay, so does anybody have any other questions regarding this item?
We wanted to just do a quick clarification regarding the requirement to update a residence address.
So as written in the meeting materials and the regulatory text presented, we will keep the sentence in that has a requirement of updating your address within 30 days, whether it's your address of record or your residence address.
I think that's very helpful because I think the average reader, it would maybe lose something and then we've set them up for citation.
Yeah.
So
Right.
by the continuity of just, you know what, you change it, tell us.
Tell us.
Yeah, I like that. Thank you so much, you guys.
Mhm.
So do we have a motion with the modified changes? Or no, actually, there's no changes. We're gonna stick
As presented.
as presented.
Whoever does bring the motion forth will read it having to do with section 4102 as noticed.
Did you get that, Louis?
Yeah.
Thank you.
Louis Arabit here. I move to approve the proposed regulatory text for section 4102 as noticed. Direct staff to submit the text to the Director of the Department of Consumer Affairs and the Business Consumer Services and Housing Agency for review. And if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, making any non-substantive changes to the package, and set the matter for a hearing if requested. If no adverse comments are received during the 45-day comment period and no hearing is requested, authorize the executive officer to take all steps necessary to complete the rulemaking and adopt the proposed regulations at section 4102 of Title 16, California Code of Regulations as noticed, with the authority to make any technical or non-substantive changes.
Do we have a second? Okay, do we have any further comments, board discussion? Do we have any public comments in person? No? David, can we please open it up on WebEx for public comment?
There are no members of the public online at the moment.
Oh, that makes it easier. Thank you. Let's take a vote, please.
Beata Marcos,
Yes.
Christine Whitlisbach,
Yes.
Ada Boone Hurl, yes. Louis Arabit.
Yes.
Matthew Greco.
Yes.
Vicky Santos, absent. Aaron Schwer.
Yes. Okay, motion carries. Thank you. Moving on to agenda number 14, discussion and possible action to consider initiation of rulemaking to amend section 4162 of Title 16 of the CCR, completion and reporting requirements.
All right, moving on to section 4162. This is another one where you can see by the language that was presented in August of 2023, this is originally part of a much larger package. We'd like to break this one out separately and move forward with it. However, this one we do have quite a few edits to what was originally presented that we feel would be clarifying and make the regulation more sound. So if I could, I'm going to go ahead and share my screen again. All right. This is maybe a little bit of a eye strain to look at here, but all of the cross out and underline matches up with what is presented in the meeting materials. However, the red underline and cross out is updates that have come from the last day or so through discussions with Reg Council. So we can just kind of go through these one by one unless anybody has any questions from the outset that they're dire to have addressed. All right. So looking at subsection B, one of the first changes that we felt would be helpful is clarifying the renewal period. So subsection B requires that a licensee maintain records of completion of their PDUs for 4 years following the renewal period. And we wanted to add in from the end of the renewal period to specify a specific date rather than a 2-year chunk of time. Or in the case of a license delinquently renewed from the date the renewal was completed. So if you renew 6 months after your renewal was actually due, you have to keep your records of PDU completion for an additional 6 months. Essentially, we reserve the right to audit you for 4 years after you renew. Moving on to subsection D, we have added in to the board just to make it clear who they have a responsibility of providing those records to. And subsection E, originally without this first sentence here, it was a little ambiguous in what circumstance you may be issued an order of an abatement as opposed to a fine or be subject to disciplinary action. So this beginning clause here attempts to just make it clear that if you fail your audit, meaning either you did not provide evidence of your PDUs or you did provide evidence, but it wasn't enough to meet the requirement, or you simply failed to respond, whatever the case may be, you may be issued a citation that could include a fine and will include a fine. In E, if it is determined that you did not actually complete those PDUs, those continuing education units, we can issue an order of abatement to make you complete them now. The reason that the distinction is important is because of the case where somebody may fail an audit for lack of response, and then after being issued a citation, decide to actually respond to us and provide evidence of completion. So the order of abatement is not dependent on failing or passing your audit. It's dependent on whether or not you actually did the units. So that's why it's clarified separately here. Moving on, we just have a change from professional development units to PDUs to be in line with how it's defined above. And then regarding structured mentoring groups, just changing is involved to participates, just to be a little bit more strict there. Change here from does structured mentoring to receive structured mentoring, and then again later on goes to provide structured mentoring. A change here to use some gender neutral language. And then, of course, all the changes that were there originally. So essentially, this aims to sort of codify the consequences and requirements of the audit process, and then just make some non-substantive technical edits. Anyone have any questions?
Yeah, where is our suggested motion?
There's not
Just
one in the
kidding,
memo?
just-
I copied it every time. Is there really not one in here?
Oh, no, we have to make this one up.
You have it at the end of the very first document, Austin, where you described the new tracker, the motion language. I think that's the only spot it was.
Well, I mean, we could really use any of the suggested motions, just replacing the number of the code section. So if we go to
4102. Okay.
the previous agenda item, the memo,
All right, got it.
and instead of 4102, it'd be 4161.
4161?
No, 4162.
Sorry.
162. Yes, sir.
Okay.
And please include as amended during the meeting.
I gotta find one of them.
Here.
Yeah, I can't do it.
I'll do it.
I think it's a little too much.
Oh, you don't want to do it.
Okay.
You want to talk.
Nope.
Okay. I'll make the motion. I move to approve the proposed regulatory text for section 4162 as amended during the meeting. Direct staff to submit the text to the Director of the Department of Consumer Affairs and the Business Consumer Services and Housing Agency for review. And if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for hearing if requested. If no adverse comments are received during the 45-day comment period and no hearing is requested, authorize the executive officer to take all steps necessary to complete the rulemaking and adopt the proposed regulations at section 4162 of Title 16, California Code of Regulations as noticed, with the authority to make any technical or non-substantive changes.
Do we have a second? Thank you. Do we have any further board discussion? Do we have any public comment? David, do we have anybody on WebEx?
No one on
Public?
WebEx.
All
No
right,
one-
thank
no
you
members
very
of the
much.
public anyway.
Great, thank you. Let's take a vote, please.
Beata Marcos,
Yes.
Christine Willisbeck,
Yes.
Ada Boone Hurl, yes. Louis Arabit.
Yes.
Matthew Greco.
Yes.
Vicky Santos, absent. Aaron Schwer.
Yes. Motion carries. Thank you very much. Moving on to agenda number 15, discussion and possible action to. It's- Can we just finish it? Or do you need to go?
No,
Oh.
just breaks for the staff, not before the 1:30 hearing.
Oh, we,
No, just live here, it's 12:30.
thank you. Okay, so we'll move this item, agenda item to tomorrow then.
We just got it and haven't had a chance to really read it, so I
Okay.
appreciate it.
All right, so then it's 12:30. We're gonna adjourn for, well, no, we're gonna have a lunch break until about what, 1:25?
What time is the hearing?
1:30.
The hearing is scheduled for 1:30.
I put it at 1:20 to make sure we have everything working.
Okay, so we resume at 1:20 for hearing. And after that, we're gonna go into closed session. So after the hearing, we really won't have any open session discussions, so. All right, well, thank you, everybody, and enjoy your lunch. And thank you, moderator.
Thank you.
Perfect timing, actually.
just wanted to see if there was something easy I could find as a reason.
At the moment, I don't have the Welcome, Miss Kudugulian. If you're available for a mic check, will you please unmute?
Oh, here we go. Okay.
Welcome.
Did I
hear
unmute
you.
myself?
I hear you loud and
Okay,
clear.
thank you.
And did I
Thank
say the
you.
name correctly?
Yes, you did. It's Kudagullian.
Thank you. All right, let's do a quick camera check, and then you'll be ready to. We're not going to get started until about 1:30. So, or not about. We are not going to get started until 1:30. So,
Okay.
let's do a quick camera check, make sure that that's working, and then you can turn those off and mute yourself for the next 20 minutes, or maybe a little bit less. I think the board is going to reconvene slightly before 1:30, but
Okay.
needless to say, 1:30 is your time.
Yes. Yes. 1:30 is my time.
All right. Are you still working on that camera?
Let me go ahead and what about now? Can you see me or how do I?
At the very bottom of the screen for WebEx, you should see a start and stop video button right next to your mute button.
Oh, here we go. Yes. Okay.
And there
Here
you
we go.
are. Perfect.
This, yes. Here. Should I go like, here we go. I'll press this down a little bit so you can see me better.
Nope. Whatever you did to the lens looks great.
Okay. Yes, I cleaned it.
Yeah. No, perfect. All right, you're all set. Feel free to turn off video and mute yourself for the next several minutes, and we'll get started in a little bit.
Okay, I'll just close the camera, but I won't unmute so I can hear. Here we go.
You'll still be able to hear, but I recommend muting
Okay.
just so like
Okay.
none of the sounds from your side come to the rest of us.
Oh, I see. Okay, I'll go ahead and mute right now. Here we go.
Are we ready on WebEx, David?
We are ready on WebEx.
Thank you very much. Ada, can we please reestablish the quorum? She's on, they're both online. Well, wait. She's supposed to be online.
W-
WebEx,
If we have our DAG, just
she's there. We don't see the picture or the video of her.
bear with us just a moment.
Okay.
No, that's the petitioner.
Oh, that's not you.
DAG Whipfler, if you're available for a mic check, will you please unmute?
There we go. Oh, there we are. And can you hear me all right?
Yes, and help us pronounce your name too, please.
Of course, it's Whipfler. It's just the way it looks. And give me
It
just
threw me for a loop.
the P and the F throws people off. Give me just one moment to get my video set up because it doesn't seem to be working here. Give me just one moment.
No worries, take your time.
All right.
If it's helpful, I have some instructions on screen for getting that video up.
Thank you so much. It's saying it says that my video's on, but give me just a moment and I'll keep working on it. Let's see here.
Perhaps the computer says your video is on, but WebEx doesn't realize it yet.
That's what I'm thinking. Let's see
At
here.
the very bottom, next to your mute and unmute button, should be a start and stop video.
Ah, there I am.
Perfect. Thank you so much.
Of course.
Okay. So let's start the meeting. It's 1:33 p.m. on February 26th. And can we please reestablish the quorum?
Beata Marcos,
Here.
Christine Whitlisbach,
Sorry.
I'm sorry.
Here.
Ada Boone Hurl, here. Louis Arabit, absent. Matthew Greco,
Here.
Vicky Santos, absent. Erin Schwer.
Here. And we have a quorum. All right, we would like to proceed with our hearing today, and now I'm going to turn it over to the Judge Warren.
All right, thank you, Madam President. Let me if I could have the petitioner, if you would state your last name, I want to make sure I know how to pronounce it correctly.
Yes, it's Kudagulian.
Okay, and that's what I was going to say, but I wanted to make sure I was correct. So thank you for that. Madam Court Reporter, are you ready? I am. All right, let's go ahead and go on the record. So we're on the record before the California Board of Occupational Therapy, Department of Consumer Affairs, State of California, in the matter of the petition for reinstatement of Anait, A-N-A-I-T, Kudagulian, spelled K-H-U-D-A-G-U-L-Y-A-N. It's agency case number 7102-025-000-982, OAH number 2025-120-802. My name's Corin Wong. I'm an administrative law judge with the Office of Administrative Hearings, and I've been assigned to sit with the board for this hearing. And to establish a quorum for the record, I'll ask that each board member respond audibly after I call his or her name, please. Madam President,
I'm here.
Madam Vice President,
Here.
Madam Secretary,
Here.
Mr. Arabit, Mr. Greco,
Here.
Ms. Santos, Ms. Schweier.
Here.
Let the record reflect that a quorum is present. Thank you, everyone. Madam Court Reporter, did you wish to make your statement for the record at this time?
Can you turn on the microphone?
A gray button on the left side.
Oh, Maria Esquivel Parkinson, CSR number 10621.
All right, thank you. Next, if I could take the appearance of the Deputy Attorney General.
Good afternoon, everyone. Amber Whitfler, Deputy Attorney General, appearing on behalf of the AG's office.
Right, good afternoon. And Ms. Kudagulian, if I could have you state your appearance for the record, please.
Yes, my name is Anahi Kudagulian.
Okay, and I note that you're here representing yourself today, which is your right. You also have the right to be represented by counsel at your own expense. Is it your desire to proceed today without counsel?
Yes.
Okay, so we're here because you filed a petition for reinstatement. So this is the hearing on your petition. And just to let you know, procedurally, what will happen is shortly, Ms. Whitfler will give a summary of your license history as well as the prior discipline. She'll also introduce some documents. And then after that brief summary, the matter will turn over to you to present your case. So what's important to keep in mind is that the board and I have read the papers that have been filed. And so it's not necessary to reiterate what you wrote in your petition. But I would suggest if there's anything you want to highlight or expand upon, that's what you could testify about. Also, keep in mind that we're not here to relitigate the underlying discipline. You'll hear Ms. Whitfler talk about that prior discipline, just in terms of giving us background as to what brings us here. And you certainly can do the same to provide context. But what the board's most interested in hearing about is any rehabilitation you have undergone since your license was revoked. And so you may feel it important to talk about the prior discipline to provide context for rehabilitation, and that's certainly acceptable. But just keep in mind, we're not here to relitigate that underlying discipline. After you testify under oath, then Ms. Whitfler will have a chance to cross-examine you, which is just a fancy way of saying she gets to ask you questions. And then after she's done asking her questions, I'll ask if you have any further testimony you want to give, and it'll be kind of that back and forth format until both you and Ms. Whitfler have finished all the testimony and questions each of you have. Then the board members have the opportunity to ask questions if they have any. And then once we go through that process, that will finish with your testimony. Now, do you have any other witnesses you wanted to call on your behalf?
No, just myself and the certificates that I have that I took since 2018.
And then we also, I saw that you uploaded documents into Case Center. Um, and I understand the board is still in the process of getting copies of those.
Okay.
So they'll be coming shortly, hopefully, but I do have them. And we could, when it comes to your case, we could introduce them. If you have any questions during the hearing, please do not hesitate to ask. I'm happy to answer any questions you may have. However, I cannot give you legal advice. Now, recognizing that you may not know the difference between a question that seeks legal advice and one that does not, what I would suggest is that if you have any questions of any nature, that you simply go ahead and ask them. And if it's a question I could answer, I will be happy to do so. If it's one that really seeks legal advice, then I'll let you know that and explain I cannot answer the question. With that in mind, do you have any questions at this time?
I just wanted to know, Ms. Whipler assisted me. Thank you so much yesterday. She said how it's gonna go, and that where I should upload, which I did, and I do have things printed. And if you know, I know you said don't repeat the same thing. Do you want me to read that letter I uploaded, or and you said the board hasn't received it yet. I don't know if you wanted me to read the exhibits. Ms. Whipler said that I should read it and then say that if you could admit it to court.
Right. So what I would suggest is when it comes to time to your testimony, let's see if the boards received the documents. And if they have not, then maybe it'll be appropriate to read the document. Or if it's going to be ultimately admitted, it's usually not necessary to read it because it'll already be in record. But you could certainly highlight certain things that you want to call attention to. Okay, that's a good question. So, any other questions?
And then the last, I guess I will have a closing statement if I'm not mistaken, Ms. Whipler, so I can have a closing. And then if I do, can I read it? Or did you want me to memorize it?
You could read it. The one thing I'd ask that you keep in mind when you do so is that when we read things, we often speak a little faster than normal. But we do have a court reporter here taking down all the testimony. And so just kind of keep that in mind and keep your, try to keep the speed of your testimony on the slower side. If you're going a little too fast for the court reporter, she may interrupt and ask you to repeat what you say. Please don't take offense. It's just that she didn't hear what you said, and she's just asking you to literally just say what you just said because she didn't catch it. Okay?
Okay, that sounds great. Thank you.
Any other questions?
Other questions? No, I think I will. I'm not sure who's going to go first. Would Ms. Whipler go first or?
Yes. So Ms. Whipler will present her summary and documents. And then after she does that, we'll turn it over to you to take your testimony and evidence.
Okay.
Okay? Any other questions?
No, that's about it so for now.
Okay. And one thing I forgot to mention is you do have the right to object to any questions that are asked. Basically, an objection is just there's some legal basis or some reason why you don't think the evidence should come in. So what I would suggest is if there's a document offered or a question asked that you have a question about, just ask the question and I could treat that as a legal objection and then apply the proper standard when ruling on the objection. Okay?
Okay.
All right. Any other questions before we get started?
No, I don't think so.
All right, very good. Ms. Whipler, if you'd like to provide your summary or your documents, whichever you'd like to do first.
Absolutely. I'll start us off just with a brief summary so everyone can know where we are and how we got here.
Ms. Whipler, if I could have you pause for just 1 second. Okay. So I was just going to say, before you continue, Ms. Whitler, I understand some people are having.
Your microphone's not on.
Oh, is my mic on? Oh, okay, there we go. Sorry. Sorry to interrupt, but Ms. Kudagulian, I understand some of the board members may not have been able to hear you clearly when you're talking. So if you just try to keep your voice up and make sure you stay in front of your microphone, that would be helpful. Okay?
Okay, absolutely.
All right, great, thank you. Ms. Whitler, sorry for the interruption, if you'd like to continue.
Thank you so much. This case comes before the board after Ms. Kudagulian's September 16th, 2018 default. An accusation was filed against the license, and no notice of defense was received. The basis of the accusation was the November 28th, 2017 conviction of stalking. Ms. Kudagulian was initially sentenced to 63 months in prison and then resentenced to 37 months. Timely notice of defense was not received, and so the board entered a default effective September 6th, 2018. The board received a petition for reinstatement on June 2nd, 2025. That petition is here in full up on K-Center, as well as some additional documents relating to the commitment offense that triggered the accusation initially. And I'll go ahead and introduce those into the record. I'll ask the court to mark for identification the Attorney General's Exhibit 1, the January 5th, 2026 Notice of Hearing, and ask that that be admitted for jurisdictional purposes.
All right, the notice of hearing is so marked. Ms. Kudagulian, do you have any objection to Exhibit 1 being admitted for jurisdictional purposes only?
No, I don't believe so.
All right, 1 is so admitted.
I'll ask the court to mark for identification Exhibit 2, the license certification history dated August 11th, 2025, and I'll ask that that be admitted unless there's an objection.
Right, the license certification history is so marked. Ms. Kudagulian, any objection to Exhibit 2 being admitted?
No objection.
2 is admitted.
I'll ask the court to mark for identification Exhibit 3, the default decision and order in the matter of the accusation against Ane Kudagulian. It's Board of Occupational Therapy, case number 170000173, dated August 27th, 2018. And I'll ask that that be admitted for jurisdictional purposes as well.
Right, so the default decision and order and the attached accusation are marked collectively as 3. Ms. Kudagulian, any objection to 3 being admitted for jurisdictional purposes?
No, no objection.
3 is so admitted.
I'll ask the court to mark for identification Exhibit 4, the indictment in the matter of People v. Kudagulian. That's United States District Court Central Division, case number CR 160770, dated November 15th, 2016. And I'll ask that that be admitted at this time.
Right, the document so marked. Ms. Kudagulian, any objection to 4 being admitted?
No objection.
4 is so admitted.
I'll ask the court to mark for identification Exhibit 5, the sentencing and judgment in People v. Kudagulian with the same case number, dated November 28th, 2017, and ask that that be admitted.
Great, the documents so marked. Any objection, Ms. Kudagulian, to Exhibit 5 being admitted?
No, no objection.
5 is admitted.
Thank you. I'll ask the court to mark for identification the Attorney General's Exhibit 6, which is the resentencing document in People v. Kudagulian with the same case number, and ask that that be admitted as well.
The document is so marked. Any objection to 6 being admitted, Ms. Kudagolian?
No objection.
6 is admitted.
All right, the following documents are Ms. Kudagolian's petition for reinstatement and the documents that were attached to that petition. So I don't imagine there'll be any objections to these coming in. I did just divide them up just to make them a little bit easier to navigate on Case Center. I'll ask the court to mark for identification Exhibit 7, the petition for reinstatement, dated June 2nd, 2025, and admit it at this time as well.
All right, the petition so marked. Ms. Kudagolian, any objection to 7 being admitted?
No objection.
7 is admitted.
I'll ask the court to mark for identification Exhibit 8, the completion of supervised release letter from the U.S. Probation and Pretrial Services, dated October 31st, 2023, and to admit that as well.
Right, so the October 31st, 2023 correspondence will be marked as 8. Ms. Kudagolian, any objection to 8 being admitted?
No objection.
8 is admitted.
I'll ask the court to mark for identification and admit Exhibit 9, the Bachelor of Science diploma from Abraham Lincoln University, dated October 26th, 2024.
The diploma is so marked. Any objection to 9 being admitted?
No objection.
9 is admitted.
I'll ask the court to mark for identification and admit Exhibit 10, the Certified Occupational Therapy Certificate from the NBCOT, the National Board for Certification I'm sorry, Case Center just did something weird on me. Give me just a moment. Excuse me. I'll repeat that. Exhibit 10, the Certified Occupational Therapy Certificate from NBCOT, the National Board for Certification in Occupational Therapy, Inc.
Right, the document is so marked. Any objection to Exhibit 10, Ms. Kudagolian?
No objection, Your Honor.
10 is admitted.
Thank you. I'll ask the court to mark for identification and admit Exhibit 11, the 2021 through 2024 continuing education transcripts from occupationaltherapy.com.
Those transcripts are marked as 11. Any objection to 11, Ms. Kudagolian?
No objection, Your Honor.
11 is admitted.
I'll ask the court to mark for identification and admit the professional development report and certificates of completion from NBCOT.
Those documents are marked collectively as Exhibit 12. Any objection to 12 being admitted?
No, Your Honor.
12 is admitted.
I'll ask the court to mark for identification and admit Exhibit 13, the micro-credentials issued by NBCOT.
The document is so marked. Any objection to 13, Ms. Kudagolian?
No, Your Honor.
13 is admitted.
I'll ask the court to mark for identification and admit the character reference letter, work performance report, and certificates from Federal Correctional Institution, Dublin.
Those documents will be marked collectively as 14. Ms. Kudagolian, any objection to 14?
No objection, Your Honor.
14 is admitted.
And this final exhibit, which I'll ask the court to mark for identification as 15, is a letter from the board acknowledging the receipt of the petition for reinstatement, and I'll ask that that be admitted as well.
Right, that letter is marked as 15. Any objection to 15, Ms. Kudagolian?
No, Your Honor.
All right, 15 is admitted.
All right, and that is all of the evidence that we will be asking to admit at this time.
So, Ms. Whitfler, there's also an Exhibit 16 and 17 in Case Center.
Oh my goodness, you're right. I apologize. I'm having a little bit of a tech issue here. So yes, let me continue then. I'll ask the court to mark for identification and admit Exhibit 16, the letter from petitioner to the board regarding the petition for reinstatement.
So the letter is marked as 16. Ms. Kutagolian, any objection to Exhibit 16?
No objection, Your Honor.
16 is admitted.
All right. And the actual final exhibit is, I'll ask the court to mark as Exhibit 17 and admit the email from petitioner to the board regarding the conditions at Federal Correctional Institute, Dublin, dated August 20th, 2025.
The document is so marked. Ms. Kutagolian, any objection to 17?
No, Your Honor, no objection.
All right, thank you. 17 is admitted.
Your Honor, I have a quick question. When will we have access to those documents? You're admitting documents that we don't have access to. So,
Okay, I was not aware of that.
I mean, you're referring to case file. We don't have that. So if you could refer to the documents that we do have, that would be very helpful, because right now, what you're introducing, we don't have a reference to that. So that's problematic.
Okay, so I don't know so I don't have the documents you have. So maybe,
Your Honor, could we go off the record briefly?
sure, let's go ahead and go off the record.
Because
Okay.
I did download a copy of a final copy of the K-Center bundle and emailed it to my contact at the board earlier today at about, I think, 10 o'clock this morning, over to Mr. Aaron Sewell. And so if I'm not familiar with the content of the materials that the board members have in hand, but if it is indeed the documents that I sent to Mr. Sewell, then they should be bait stamped with the same numbers as those documents in case lines, or case center, I should say, and they should
Correct,
be the
Deputy
same
Attorney
documents.
General, we do have it and it is bait stamped. I don't know if you can give us the beginning bait stamp number of each of the exhibits for the members?
I see I see that's the problem, then it must not have, it didn't have the index then. Yes.
Yeah,
I
the
can-
bait stamps are on there, but I think it's just confusing because it's all one package.
Right. So I could clarify
Absolutely.
that for the board members. And there are some documents at the back that look like are not in case center. It looks like it's the petition, which I think is duplicative. And then it looks like they do not have any of Ms. Kutagolian's documents. Is that, well, the ones that she uploaded directly to.
The ones that we just got, they're bringing them over manually.
Okay, so I think, yeah, I think I know, what's been received. So, or what the board has. So let's go ahead and go back on the record. So I think I could add clarity. So the Exhibit 1 in the packet that the board members have consists of the documents that have a bait stamp in the bottom right corner of A1 through A4.
It looks like they also have an index.
Oh, okay. I was just pointing out, there's an index right at the beginning of your packet.
If you turn the page from the actual cover page, there's the index of each of the documents she just listed with the bait stamp number.
So each separate group of numbers would correspond with a separate exhibit. So for instance, A1 through A4 is Exhibit 1. And then Exhibit 2 is A5. Exhibit 3 is A6 through A15, and so forth, all the way down to Exhibit 17 is the last group of documents, which is A168 to 169. And then there are petitioner, Ms. Kudagulian uploaded additional documents yesterday that I understand from council are in the process of being delivered, but I haven't discussed those yet. Okay, thank you for pointing that out. Thank you, ma'am.
And members, just for clarity, those are the documents that we referred to at the beginning of the hearing where the petitioner asked if she needed to read those letters. And we said, when that time comes, if you have a copy, because that is what we're working on now, then she won't need to read the whole thing. Otherwise, she can read it into record. But you will have those as soon as we can provide them.
All right, thank you for that question. Ms. Whitfler, I'm not sure if we interrupted you or if you finished your presentation.
No, there's
Do you want to go
nothing.
back on the record, Your Honor?
I believe, yeah, we were back on the record.
Okay.
Yeah, thank you. Ms. Whitfler, had you finished?
Yes, that is those are all the documents that we seek to have admitted.
All right, thank you. All right, so Ms. Kudagulian, now is your opportunity to present your evidence. So, do we have a status on her documents? Are they still in process of coming?
Yes, so what she has here, the DAG is already admitted is what we have.
Right.
And then the other ones are coming in.
Do you know about when they're going to arrive? Okay. Okay, so Ms. Kudagulian, let's go over your documents first.
Okay.
And I believe what you uploaded as what would be your Exhibit A are the documents that Ms. Whitfler included as Exhibits 7 through 17. Because I saw that they appear to have the same Bates numbers, so A1 through A169. And I just wanted to make sure that those documents are in fact duplicative.
Oh, you're asking me, Your Honor, if they're
Yes.
duplicative? The documents that I uploaded, I believe it was yesterday and then the day prior. And Ms. Whitfield, they're the same, right? They're the same ones that you also received?
Yes.
The communication between me and Occupational Therapy Board, the 30-day notifications, that the Occupational Therapy Board was accusing me of not receiving, but that I have evidence that the 30-day notifications when the incident happened, there's communication and evidence of that, because the board accused me of not notifying
Okay,
them
so-
within 30 days.
Ms. Kudagulian, hang on, I don't want you to get into testimony yet because you're not under oath. But what I'm trying to determine, do you have access to Case Center right now?
I can't log in, I believe. But if Amber says it, then I believe it, that, yes, that's the same one, because I emailed her also asking her if she could, she explained to me. So if Whitfler says it, then I would say, yes, it's that same evidence.
Well, I want to confirm because if it's duplicative, we don't need it.
Yes, I can. I'm sorry, I didn't mean to interrupt, Your Honor.
No, go ahead.
Yes, it does look as though what's in here as petitioner evidence 1 is indeed a copy of the AG's submitted evidence.
Right. Okay. So I was able to confirm that from the Bates numbers, but
the remainder of the evidence, 3 through 8, are not included in
that's
the
what
evidence I submitted. So the board members will certainly want to see those.
Okay, that's what I wanted to confirm. All right. So let's first take care of the first packet. So we'll mark the first packet as Exhibit A. It's the Office of the Attorney General's documents, Bates stamped A1 through A169. Now, Ms. Kudagulian, since they're duplicative, do you want to withdraw them or do you still want to have them in the record? Twice?
Well, if it's duplicative, probably not. I would probably
Okay.
want that withdrawn if
So-
it's the same thing, obviously.
Okay, so do you want to withdraw them?
Yes.
All right, so we'll go ahead and withdraw those as duplicative. Um, hang on. What I will do is I'll hold off on the other documents at this time because the board members don't have copies. And they're en route is my understanding. So what I would suggest is if you want to provide your documents, or excuse me, if you want to testify about the documents that you provided to the to Ms. Whipfler, we could do that. And any other testimony you want to provide, but reserve testimony about the additional documents until the board members get those documents, so they have some context.
Okay, I could read, would you like me to read the letter that I wrote? And I believe I sent that yesterday. Just in general, it explains.
I
uploaded that
would
letter.
wait until, I guess you could read it.
It's in general term, and then I have the.
Yeah, it sounds like it's going to be here in 5 minutes. So why don't you start your testimony on the first group of documents that the board already has. And then we could go from there. So then we'll have the other documents. So we'll know what you're talking about. All right.
Okay.
So first, before you start, let me swear you in. So let me have you
Okay.
raise your right hand.
Okay.
You solemnly swear or affirm under penalty of perjury that the testimony you will provide in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you may put your hand down. If I could have you start by stating and spelling your full name for the record, please.
Okay, my name is Anahid Kudagulian, Anait, last name Khudagulyan.
All right, thank you very much. So just as just a reminder that we have a court reporter here today taking down your testimony. So if you would please keep that in mind and keep the pace of your testimony on the slower side. It certainly would be much appreciated. Also keep in mind, if you would, that what the board's most interested in hearing about is any rehabilitation you've undergone since your license was revoked. So with that in mind, I'll turn it over to you to provide your testimony.
Okay, so do you want me to talk about the PDUs, the continuing education that I uploaded 2 days ago? And then the rest of the.
What I would suggest to make it kind of make more sense is maybe you want to talk in chronological order. So talk about in terms of history, what happened, and then
I see.
what rehabilitation you've undergone. That might make the most sense and be the easiest to follow.
Okay, so I did write down in detail, but yes, so in 2016, I was arrested and indicted for stalking. In 2017 was the sentencing and conviction. I believe it was 63 months. That case was vacated due to errors from the judge. And in 2018, the board filed a accusation of default and decision. However, at that time, when and I believe you have the evidence of the conditions that I was in prison, the whatever letters that I received as the board wanted to, they were asking me what, what documentations I need to provide, what communications, and I sent a letter out, which I believe you have. I'm not sure. I'm sorry if you have that letter, but the board then. Later said that they never received any letters from prison. I explained to them that that was probably part of the misconduct and investigation that later the FBI did on the FCI Dublin, including the mail, other misconducts that were happening, holding on holding off complaints, and hence the board didn't get it. And when they did not receive it, I later found out, because at that time I was still in prison. There was mail I was receiving, there was mail I was not receiving, and that, you know, it was not my fault. As I said, that was the mishandling of the prison. But then later I found out that the board did the accusation and default decision due to not getting any response from me from prison. And that's what happened. And then I'm trying to think so 2016 arrest. Should I talk about the other communications to the board or not yet?
If you think it's relevant and then, yeah, feel free.
Okay, so just to go back to the 2016, when the incident happened, within 30 days of the incident, as soon as it happened, within 30 days, in a timely manner, I contacted the Occupational Therapy Board, and I submitted the evidence of that, and I let them know that what was happening, that I got arrested and there's an investigation going, and by law, I'm supposed to notify them within 30 days. So hence I'm notifying them within 30 days. And then the Occupational Therapy Board said to us, well, please let us know if any changes or anything happens. Make sure you do that timely. And so in 2017, as this case was going, I was sentenced and convicted for 63 months. And during that time, again, I sent a letter and emails to the Occupational Therapy Board explaining them that within 30 days, I want to, as I'm required to do so, I want to let them know about the case and what's happening. And I believe I attached the indictment so they can be aware of it. And 2018, oh yes, 2018. So I explained the 2018 situation, which was the board again wanted to know what was happening, and I responded back, but then later learned that a default decision was made against me because they said they never received any letters. And again, I'm going to blame the prison for that, because that was a misconduct that they were later being investigated for. And then 2019, I was resentenced to 37 months, 3-year probation for good behavior, because as I was in FCI Dublin, I was continuously taking courses. I, was not going to allow anything to stop me. I was like, I'm going to better myself. I'm going to exercise, better myself, become more knowledgeable, and heal and find out what happened. And so I took a lot of courses, a lot of certificates, and that was 2019. And in 2020, because of the certificates I took, because of the good behavior, they allowed me to go 6 months early to halfway house, which they released me in March. And also, while I was there, one of the employees, I believe you have the letter from Mr. Long, I believe, he was our employee because I was working under him. He gave me a recommendation letter, and he said, "You're wonderful, you're healing," and I'm going to write a letter so you can take it, because I said to him, I'm going to need a recommendation because my board is going to want to hear from me. So as I'm healing and I'm, doing better, and he said, okay, absolutely, I'm going to give you a letter. And he said, you should definitely go home early and get your career back in order. So hence I got that letter from him. And then the many certificates from Bureau of Prisons that I received. In 2020, I was sent to the halfway house that was still under BOP. So I was there during that 2020, and then which I opened my business, the wedding content creating, the celebrity wedding content creating little agency. So I did that in 2020, and I did it, and I was under supervision. And then 2020, 23, I was off probation. But during that time of 2020, as I was under, I was in a halfway house. During 2020 to 2023, I was under, I believe it was 3 different probation officers. As you know, they get promoted, they go. But, all 3 of them worked with me as I was doing my business. As, I was getting more clients, working with delegates of other nations, including kings and queens of other nations, including president. I had an opportunity to work with President Trump's family and friends, and they assisted me a lot because of the wedding content creation films that they were giving me. So my business bloomed, and it's still doing well. But so I, started getting help and working with different people, different agencies. And during this time, I was being supervised, and the probation officers, they were very happy, and they were surprised that I was in touch with so many high level people, and they were very proud. They were telling me, that's wonderful that you went through all this, and you're being monitored. You went through all these things, and you established a business. And the celebrity, I work with celebrities. Like I said, I work with politicians, with their family members. I post weddings for their kids. I had an opportunity to work with people from Israel, with important people. So I was extremely happy that all these people trusted me to, with their confidential information, with their personal photos, with their children's information and dates. And I had to take that in, create content, promote them, and established a connection, where people trusted me. And that's what I've been doing. And I've been doing that till now. And of course, now I'm promoting Mr. Trump and his family members. I still continue to work with them. I did want to work with President Biden's family, but at that time, the the event planner wouldn't allow me to make adjustments, so I didn't. But I wanted to work with the Democratic side also. But thanks to, like I said, in the beginning, I had very low clients, but I had an opportunity to collaborate with people from Israel, which their content literally helped me, as I had a very low level followers on my YouTube. I think it was just a few hundred, but because of the special content that I got from Tel Aviv, that helped me as I started uploading. I got more followers, more people wanted to communicate with me. And that's part of the business where until now, where I have millions of people at my YouTube channel. I believe I have over 100 million viewers. I have 250,000 followers, but I'm constantly in communication with everyone. I have to be professional. People have to trust me because they do, because for example, if the president is traveling somewhere and I get to know about it, I have to just keep confidential, keep quiet about it, and make sure everyone's safe because, as you may know, but because of the political reasons, since 2020, actually, when I got started, because of the political reasons, everyone gets threats. I also continue to get threats because if I post something that has to do with a Jewish wedding, or if I'm collaborating with an Israeli businesses, I get threats from Middle East. So I have to keep my cool and my calm. And in the beginning, when this started happening, as I started promoting King of Jordan, I started working with the planner. I started working with the King of Brunei's personal photographer, his family members, and then Myanmar, and then so it was Tiffany Trump's personal family and friends. So I started getting hate emails and threats, and so when that started going, David said to me, just he said, so that we don't get into problems. He said, take a picture, and then whenever these things happen, as you're growing your business, just report it to each social media outlet. He said, we don't want it to be where this becomes a problem and you're back in trouble. So he said, let's pay attention. So I have been under supervision since I would say 2017, 2016 even. And during the 2016, when I got arrested, I was allowed to work with patients. So I worked for 2 years without any problems to any patients. I worked wonderfully with everyone while this case was going on. I continued working, providing treatment, going to different facilities, and until the 2018, where I had to check myself in and go to prison. Then obviously I could not work any longer, but until that time, and until now, I feel very blessed that I was given opportunity. I get to work with very essential, important people, and get to and part of this includes me paying attention to confidential information, confidential videos of locations where delegates have to be, and I know about it, or videos that I'm receiving internationally, and I have to keep quiet about it and be professional, and have to be polite. I have to. I also work with, like I said, the King of Jordan's family and friends and the planners, and I have to pay attention to what religion they're coming from. There's content that people trust me from Israel, where it's personal information or children of important people that are in the government and it's their wedding, and I have to take that in and do videos, share the content, write about them, and as well as hundreds of thousands of comments, complaints, and threats that goes under my video that I also address, and I have to do it
Okay,
professionally, which I do.
Ms. Kuda-Gillian, let me give you, try to give you a little more guidance. So focus on what you have done on your rehabilitation.
Yes.
Or,
Um,
so why, so in other words, you engaged in conduct that the board felt warranted an accusation, and then your license was revoked. Now you're asking that your license being reinstated.
Yes.
Focus on explaining why should your license be reinstated, even though you engaged in this prior misconduct? How are you safe to continue practicing under your license?
Yes, and this is why I wanted to
Okay.
explain all this,
And actually, let me give you a chance to kind of gather your thoughts, because I understand the documents have arrived. So we'll get those circulated. And so I'll give you let's take a short recess to get those circulated, and let's go ahead and go off the record. All right. Ms. Whitfler, do we have you online? Ms. Whitfler, if you could hear me, oh, there we go. All right, great. Let's go ahead and go back on the record. So we have confirmed that the board has received copies of all the exhibits that have been bait stamped through what B as in boy 187. And so they're just missing at this time B 188.
Your Honor,
Go
would
ahead.
you like to establish that all members of the board are here? You want to at least put that into the record?
Sure, we can go ahead and do that. Let the record reflect that the members of the board who previously were present are back, so we do still have a quorum. So looks like the only documents in Case Center that the board members do not have are B188 and B189, and then Z1 through Z8. So those are being copied at this time. We will have them in time for deliberations. And then, of course, I do have them in Case Center, which is our official record. So I think we are good to go now. And if there's things you wanted to read from them, Ms. Kugulian, you certainly can. But since we have the exhibits at this time, let's go ahead and take care of your exhibits and get those marked and moved. So there's email correspondence that is bait stamped B173 to B178. We'll mark that as Exhibit B as in boy. Ms. Whitfler, any objection to Exhibit B being admitted?
No, Your Honor.
Okay. B is admitted. And then the petitioner's December 4th, 2017 correspondence, which is bait stamped B179, we'll mark that as Exhibit C. Any objection to C, Ms. Whitfler?
No, Your Honor.
C is admitted. And then we'll mark as Exhibit D. It's the first two words are acronyms. The first one is OTR, and then ampersand COTA, and then credential verification. We'll mark that as Exhibit D. And those are, excuse me, it's only one page, so it's Bates 180, B180. Any objection to Exhibit D?
No, Your Honor.
D is omitted. Exhibit E is petitioner's request to, or request to admit petitioner's exhibits. That's Bates B181. Any objection to Exhibit E?
No, Your Honor.
E is admitted. And then we'll mark as Exhibit F, continuing education transcript for November 12th through 16th, 2024. And it looks like that's Bates B182 through B187. Any objection to Exhibit F?
No, Your Honor.
F is admitted. And then Exhibit G is petitioner's February 25th, 2026 correspondence. That's one of the documents I mentioned that hasn't been printed yet. It's B188 to B189. Any objection to Exhibit G?
No objection, Your Honor.
G's admitted. And then last is Exhibit H is a continuing education transcript, February 4th through 7th, 2026. And that's under the Z categories in Case Center, and those are bait stamped Z1 through Z8. Those are also in the process of being printed for the board members. Any objection to Exhibit H?
No, Your Honor.
H is admitted. All right, Ms. Kutagulian, that's all the exhibits I have for you in Case Center. Are those, in fact, all your exhibits that you wanted to admit? Whoops, you're currently muted.
Yes, Your Honor.
All right,
Yes.
very good. If you'd like to continue your testimony, sorry for the interruption. Thank you for indulging us. I remind you that you're still under oath. And so if you'd
Yes.
like to continue, whenever you're ready.
Yes. And so Your Honor, the reason I was mentioning all these things was because that's part of my rehabilitation and growth. I wanted to say that since 2018, I've completed all court condition classes. I've been released without violation. I have taken, as part of the rehabilitation movement, I've taken ethics education. I've taken classes on professional boundaries. And I have all of it. I've taken, as related to my field, on how to treat patients with strokes, occupational patients, how to treat dementia patients, how to care for them carefully. And since 2018 until now, I have taken many courses related to the AOTA Code of Ethics, related to my occupational therapy board, related to my field. I've done pediatric classes relating to children and occupational therapy, how to treat children, how to work with patients in how to do assessments, intervention, how to work with patients in nursing homes with the elderly, how to work with mentally ill patients. I have taken courses since then as part of my rehabilitation, and stress management, enhancing well-being. I've taken many courses, as you may have seen on the PDU certificates, which are also part of my requirements. So within that time frame, I have met all the requirements, plus more. And the NBCOT, which I was very happy about it, the NBCOT, when I give them all these documentations, they recognize my rehabilitation efforts, my growth, and they did give my license back to me without any conditions, which I was very happy about. So currently I am nationally certified, and also I have been since 1998, and that was part of the date error, I believe. I uploaded as evidence because the Occupational Therapy Board, on one of the letters, I believe there was an error. Was it, I'm trying to think, was it Aaron? It was in the beginning. He said I was an occupational. Let me see. Austin Porter, I believe there was a letter that he sent where he said March 19, 2003, she's been licensed as a CODA, but that was the error. I have been licensed since 1998, and the NBCOT evidence shows that. That's also on their licensing website. And hence that's why I wanted to say that since that time, since during actually even incarceration, even when I have been out, I've been working on my professional ability to work with people, to have people trust me, because obviously that's part of the occupational therapy ethics code, to be responsible, to have integrity, to safely practice with people, to have people trust me, to be ethical as an occupational therapy system. We do billing, we work with patients, we keep information confidential because this has to do with their illness, with their rehabilitation. So I've taken many courses since then, and I've been under monitoring really since 2016, I would say. And like I said, from 2016 till 2018, I was still continually working, providing great care to my patients. I was going to different nursing homes and working. And then from 2018 until now, although as I was explaining, I work with wedding content creation. I did that also, but meanwhile also took courses and worked on my occupational therapy. So I did two different things, been constantly working on myself to as a rehabilitation effort to show and as evidence my growth, and to show the board that I should be trusted. And that I've been working with all these people from different backgrounds, different religions, and as part of the board, of course, I'm sure concern is can I be trusted? Can I work with patients with different backgrounds? Can I keep information confidential? That's part of the occupational therapy concern and part of the licensure and part of the professionalism. And I wanted to bring all this evidence and talk about it that sort of shows it's proof that I've continuously sustained rehabilitation. I've demonstrated since 2016, since this incident until now, I have not had any problems. I've been in good standing. I've earned a bachelor's degree, and I completed extensive, as you see with the evidence, the CEUs and the PDUs. I've continually been active to earn more education, more and then specific courses and specific, as you can see, specific to whatever happened with me. So specific to ethics, specific to integrity, specific to confidentiality and treatment. And as this is important for the Occupational Therapy Board, and a lot of these courses are AOTA certified, and also the NBCOT. I've taken courses on their website. I work with Mary Vale, and she also assisted me on the process. And like I said, I was extremely happy that the NBCOT trusted me and gave my certification back to me without any monitoring, and she also saw all these documents, and she was very proud, actually. We spoke about this, that I completed all this. I've not had problems, and I'm planning to go, and I'm hoping that I will get my OT license here in the COT. And then my goal, as I was explaining to Janine from the OT board, I was telling her I really want to continue and get my master's in occupational therapy. I did find schools to go to. However, one of the admission requirements is that I have to have a license in California. So I have to hold on that until a decision is made by all of you. But yes, one of the decisions, one of the requirements to go to occupational therapy school to get master's or a doctorate in occupational therapy, which I want to because Howard University also has classes online. So I do want to continue my education. I love the field. Like I said, I've done it since 1998. I've never had any patient-related problems, concerns, complaints, no fraud, no, HIPAA violations. I've liked all my patients. I've cared for them, and have never had any problems until this incident that happened. But I'm hoping that I'm gonna have an opportunity to get my license back and then to continue further education if possible.
No problem. Thank you. Did you finish your testimony at this time, and are you ready for Ms. Whitfler to ask questions?
Yes, she can ask me questions, sure.
All right. Ms. Whitfler, cross-examination?
Thank you so much. Before your term of incarceration, what kind of work were you doing?
Before prison, I was working as a occupational therapy assistant, as a COTA, and I have been since 1998. That's all I've known. And before 1998, I was working as a secretary. I was working as a secretary in a nursing home. So I've been in a healthcare field for quite a long time. When I was 18 years old, I worked as a secretary in a nursing home, at which point I became friends with the occupational therapist. And she suggested she said, you're really good with patient care. You're such a caring person. You should study occupational therapy. So upon her recommendation and her, as she gave me a letter and then had me admitted to Mount St. Mary's University, and that's where I got my COTA education, my Mount St. Mary's University. And
Okay,
then,
and
okay.
oh, and were you working primarily then with an elderly population of patients?
Yes. I was working, so I've literally been in nursing home. I did afterwards, had an opportunity. There was an occupational therapist, and she said, should I really trust you? I really like you. Let's go ahead and expand. And I wanted to get a contract with the regional center, and could we work with pediatrics? And I said, absolutely. I'll go ahead and take classes and, more PDUs, and I'll train, and let's do it. And that's what I did. And then I did that angel rehab therapy. We did it in Palm Springs area. We had a contract with the regional center and worked with pediatric population from birth to 3 years old with various diagnoses. And so I had an opportunity to also work with pediatrics, and that was wonderful from and I also did home health. I did home health also because with the pediatric, it was a low income area and the families couldn't afford it. So they asked us if we could go to their home because they couldn't drive anywhere. So I lived in Palm Springs. I also did my internship in Palm Springs, but I lived in Palm Springs, so I would go and see the patients in a low income area. And that was wonderful because they're in Hemet and other low income areas. They did not have enough therapists to treat the children who were being born with so many illnesses, and they needed therapy. And I'm glad that I assisted somehow, that I helped them.
All right. And then if you do get your license back, do you plan on immediately returning to the field?
I do want to immediately return. Yes, I do want to immediately return to the field. I was talking to a friend of mine who's a physical therapist. She already said Genesis Healthcare is hiring, and I got in touch with the people I used to work with. So they asked me, they said if I could come back and work there. There's a shortage of occupational therapy assistants. As you know, with administrations, they were a bit challenging with the immigration population and with the licensing of H-1 visas. So then I realized that there's a shortage because people are not being, the licensed occupational therapy assistants are not being allowed in, unfortunately. So, but there's a shortage of it, and they want me to go back to work. Yes, and I would love to apply immediately. As I said, do have my NB COT, but however, I need my California to immediately apply. And I would love to go back to work if I can, as I have many certificates. So as that's one of the requirements with the nursing home and jobs, that I'm up to date with the certificates, which I am.
Okay. And for the record, can you tell us what NBCOT certification? Can you tell us what that is?
National Board of yes, I have it right here. National Board of Occupational Therapy, the Professional Occupational Therapy Development. This is a national board that certifies occupational therapists nationally. So let's say if I wanted to go work in Nevada, or I wanted to go work in another state, if I wanted to be a traveling therapist, I could do that also. However, it depends what state. There are states who don't require require a state license. So there are states who might say, well, we'll just take your NBCOT and you're good to go with that. And there are states who do require, and I did look into that. I think it was Nevada. I did look into that if I could do, take work until my California works out. I did look into it, and the board member said that it'll be great. They will approve usually they approve applications if you're, you know what I mean? If the matter is resolved, or if I'm approved in California, that gets my chances up for me to get approved for licensure in different states. So the California incident kind of hinders everything. I'm waiting to kind of resolve this issue so I could, work in California, do traveling occupational therapy. I would love to do that too if I can. But as I said, everyone's kind of hinting that California has to be handled and resolved so that when they're reading that it makes look and it gives me a higher chance of getting my licensure in different states.
Okay. So what has you mentioned earlier about your content creation business. Other than that, have you been employed in any other fashion?
I have just been doing this. I did do, I am a caregiver for my mother who had aneurysm. So now her aneurysm's healed, but I do caregiving for my own parent, for my mother. And then I do the wedding content creation also. So I constantly know what it's like to, take care of an elderly person who's in need, who needs to be taken care of. And yeah.
Okay. And does the content creation, does that provide you with an income?
They do. I do. It does provide me with income as YouTube pays me for the content creation. But sometimes they pay me, sometimes they don't. If it's content that it's something new that they came up with that everyone's talking about it on YouTube. But if it's content they approve, they pay. If it's content they don't pay. So it fluctuates based upon what they approve, which is kind of unfortunate because I do have over 100 million viewers, and each of my videos, if you go on YouTube, you see has millions of views. But yeah, that's unfortunately it's not enough income for me to sustain independently.
Okay. And when you use the term content creation, does that mean the creation of videos that are then posted to YouTube?
Yes. So what happens is, for example, if someone's getting married, or whether nationally or internationally, as I said, then I have to work with the photographers of that nation, or the wedding planner. It could be separate or individually. And I could go myself and videotape the contents, or the photographer simply videotapes the event and sends it to me. And then I download it, and then we go back and forth. What music should we put? Where should we cut? What is the bride like? What should we, what's the story behind it? If people make mean comments, what should we do about that? Because as you know, people get sensitive, people make comments about them. So I go back and forth as to negotiating on.
Ms. Kutagulian, you're talking way too fast for the court reporter.
Oh, I'm sorry.
So
I'm sorry.
you need to slow down. And the other thing is, make sure you're answering just the question asked. You're going way
Okay.
beyond the scope. Okay. So
Okay.
limit the scope of your answer to the question asked.
Yes. Okay. I'm sorry.
All right. Now, let's talk about the underlying incident that led to the accusation. Have you identified the causative factors that would lead you to behave in such a manner?
Yes, I did. So initially when this happened, my I was going through some things. My mom was diagnosed with aneurysm. My husband was diagnosed with illness. And so at that time that I was going through many emotional things. But since then, and after that, I saw a therapist, I saw a psychologist. We talked about it and we resolved it. And so now I know boundaries, what needs to be done for, restrictions, not reading too much into comments or not to get too much involved emotionally on topics or anything, no matter what it is, whether it's wedding related or whatever it is, to keep my cool, to keep myself calm, and to just concentrate on the business and making sure that everything works out good.
Okay. And when did you receive therapy?
Initially, when people, I'm not sure, I'm sorry, I shouldn't say as but initially when people get arrested, the court requires that they go through an assessment. It's a court ordered a report. And so I did do that. I did go and Miss Virginia, I believe she authorized it. She said, I want you to go get an assessment so we can figure out what happened and how, we can prevent this. And I did, and then they signed me. It was she was not a therapist, she was a counselor, I think. It was short term. And she said, you're great, you understand what happened. It was a mistake.
Ms. Kudagulian, let's focus on the question. The question was when did you do therapy?
Yes, so it was in the beginning. It was 2016. It was 2016, I believe, that as soon as I got arrested, then that was ordered and I went for assessment.
Okay. And have you received any therapy or counseling since 2016?
I believe, if I'm not mistaken, I'm not sure. I don't remember. I believe in 2017. No, I'm sorry. After I was released, I believe David said, "Oh, because you came out of prison, I don't want this to be traumatic. You talk to a counselor," and I believe I did. It was the same counselor that I spoke with before, and she said, "You're doing great. You don't need to come see me."
Okay. And what about after your release? I'm sorry, this was after your release from prison?
Yes, after my release. It was a
Okay.
short time. It was a very short time. She said, you don't need to come. You're doing great.
Right. So, according to the indictment, the conduct for which you were convicted took place between April and October of 2016.
Okay.
So that's about a 6-month period of time. How could you explain the length of time that you engaged in this conduct?
How can I explain what happened? Is that
Yeah.
what you're
Or if how can, I guess, if you could give us a better sense of how did this go on for so long and why?
Yeah, at that time when this happened, I was like I said, I was getting harassing phone calls and texts, and for some reason I thought that the agent was involved or his family was involved. But we, later learned that was not true. And of course, I was wrong in that. I should have, even if I thought somebody was harassing me or stalking me, I should have never allowed this to go on. I should have just simply filed a police report and closed the chapter and take it from there. But that was a mistake I made. I take responsibility. I wasn't thinking right, and that was very wrong. And I'm quite embarrassed about it. And I
Okay.
don't even really think about it anymore.
Okay. And what does it mean to you when you say I took responsibility for it?
Well, I took responsibility because it was my fault. He didn't deserve it. I should not have. It doesn't matter if I thought he was harassing me or his wife was harassing me or whatever it was. As my attorney also said, he said, if you think someone's harassing you, you don't take that into your own hands and you don't do investigations. You don't need to do that. You file a report and take it from there. You don't, don't bother anybody. And I completely agree. That was embarrassing. I can't imagine now when I think about it. I sometimes I'm in shock myself when I read it and I go, oh my God, I can't believe I said that. But I cry about it sometimes. I'm like, I can't believe I said that, or I can't believe I did that. Like I'll get embarrassed about it because it was wrong. It was wrong. He didn't deserve it, and his wife didn't deserve it. It was wrong, and I made an error, and I
Okay.
apologize for it.
Okay. Let's talk a little bit more about the rehabilitation efforts. Now, you mentioned that you got a college diploma. What sort of degree did you get?
It's in business administration. I went to Abraham Lincoln University. It's in Glendale. I was very happy about it. It gave me an opportunity as part of my growth to learn about business, to learn about negotiating, behaving. And my professors actually worked for the government. They worked for the FBI. My professors worked for the IRS as investigators. So they were teaching me like, this is what you do. And, these are boundaries. This is how you learn business when you're negotiating. This is how you behave. You have to keep your cool, keep your calm. Don't misinterpret things. Don't, so that was so helpful, as that provided me as part of my growth and rehabilitation, because I learned more and more information. I feel like I became more intelligent by just reading and receiving help from my professors as mentors.
Okay. And you mentioned techniques to stay calm. What are some of those techniques?
So a lot of, and I do, and I'm so glad you put that in the as evidence, as we have here. I started watching podcasts. I started reading Oprah's podcast. I started following on Instagram and other platforms mentors, who talk about it, and this exact thing where they talk about boundaries, how to behave, how to control your emotions, how to interpret things correctly, how to keep yourself safe and other people safe. So I'm continuously learning. Even at night, I watch podcasts. I'm learning. I'm taking notes. I had the opportunity to on Instagram and on a podcast, listen to an FBI agent, Mr. Chris Voss, who wrote a book about it, on how to behave, how to, how to interpret things. So that really helped me. And that's what I do. I have on my phone list of books that I purchased online that I listen to at night also, in addition to the certificates. And also on social media, I'm constantly following. And as when you sign to certain mentorship, or you're watching someone, you're constantly getting notifications of new treatments, new ways to behave, new ways to prevent problems. So I'm doing that also.
Okay. Um, if you had it to do over again, what would you have done differently to prevent the actions that resulted in the conviction?
I would have now that as I said, now that I watch all these podcasts and all these government agents who give advice, um, and um, and after that, when it happened, and all these education and everything that I received throughout the years, I simply should have just under stress, I should have just seen a therapist. I should have just, if I'm stressed, not to, talk to your family members and have them give you advice. That causes confusion. Your friends give you advice, and this is also what happened, was part of it. That to just, if you're stressed out, I should have just spoke with the therapist and said, "This is what's happening. This is what I'm feeling. What's your opinion on it?"
Okay.
you know.
All right. And if the board made therapy or mental health programs a requirement of reinstatement of your licensure, would you be willing to do that?
Well, if I have to, of course I would. But I do feel that I've gone through enough of therapy since 2017, and I've gone through enough courses, mentorships, and I continuously do. You know, and I would think it's enough. I think I'm ready, as also since 2020 of me coming out. And as I said, you have to be very mentally stable to work with dignitaries, to negotiate things with them. So I think I've been okay. So, but I mean, if the board required, of course, I would do it if they felt that I needed it. But I'm hoping they won't, and that they will take into consideration my work habits, my business in 2020, my continuing interaction with people of different cultures, religions, of having not any problems. And I hope they consider that, and they don't think it's necessary.
All right. All right. I have no further questions at this time.
All right, thank you. Ms. Kudagulian, is there any further testimony you wanted to provide on your behalf?
No, I just wanted to, is this like the closing?
No, not closing yet. Just any
okay.
other additional, anything else come to mind that you wanted to testify to?
Just the documentation. I just wanted to make sure that everyone received that, as far as the violations sort of that was on me on the 30-day notifications. I just want to make sure the board knows that I was responsible, and that I notified within 30 days in 2016, 30 days in 2017, and in 2018 I sent it from prison. So I just want to make sure the board knows that I was responsible, and I, you know, as evidence shows, I tried to notify the board so that there were no violations, and they knew that I was, taking responsibility, and I was on it.
All right, thank you. Ms. Whipler, anything further on recross?
No, Your Honor.
All right, next I'll turn to the board to see if there are any questions. Madam President?
Yeah, hello. Some of my questions were already answered, but you stated that you got your license in 1998. Is that correct?
Yes.
And that
Yes, I
our
did.
board sent you the wrong information, saying it's 2003?
Yes.
Okay, so our board didn't start until 2001. So I'm just curious on what kind of license did you get in 1998?
Oh, so the occupational therapy board didn't start until 2001?
That's correct.
Okay, because I became certified after I graduated Mount St. Mary's University. I started after I started my own service. Oh, so I'm wondering if the board later then maybe created, because I was able to work. So what
Okay. So when did you get your license officially then, that you are aware
in
of?
19 so let me tell you what um I graduated from Mount St. Mary's. Here we go. So Mount St. Mary's University. Yes, so I graduated from Mount, and I'm sorry, I don't have the date of my resume, but after I graduated from Mount St. Mary University, our university told us that we must go through first with NBCOT and apply for licensure so we can start working. And that's what I did. I applied and then started working, started seeing patients, like literally going to work.
Yeah, but when did you get your license?
In
What year?
1998.
No.
As soon,
Would have passed the NBCOT exam.
Yeah, when you pass your exam, you go to your license. You can go to work.
What I'm trying to say here that when you received the letter from Executive Officer Porter, it was correct. You got your license in 2003.
Okay, so in 2003, yeah, and that's what I wanted to make sure because, as you know, a lot of time has passed. But because when I looked at the date on the NBCOT, I said, how was I have to work. I can't work without a license. That's what I was confused about. I said, I can't work without a license. Why would he say 2003 when I was at NBCOT certified? And that's when I got my licensure, as it says on the NBCOT website. So,
Yeah,
probably that
very
was
two
an error.
different
So,
entities. Yeah. All right.
yes.
Thank you.
So, thank you for clarifying.
Ready? Okay. Okay, so I have a couple questions, and I just want to thank you for being here. And a lot of my questions have been answered, but I still have some
Thank you.
big questions. And the judge is going to help me here. If I overstep at all, he's going to help me here. But I'm having a hard time trying to figure out this rehabilitation thing. Sorry, I can only see far away or close up.
Okay.
So my glasses are going to go off and on. I'm having a hard time figuring out whether or not you're rehabilitated, because that's what our job is here. Because I don't
Okay.
understand, based on the information that we have in front of us, exactly what happened that brought you here. And I know that we tried to get to that during the hearing, and you're saying that you don't really want to talk about it or think about it, but I need more information to figure out if you've
Oh,
met
absolutely.
rehabilitation. So I don't know what happened. If you can you provide a little bit more detail on how we
Yes,
got here?
absolutely. Yes, I was charged with stalking, and let me go ahead and take out my paper because I believe I submitted also the list of the answers. Let me see. So in 2016, yes, I was arrested and indicted for stalking. And in 2017, I was sentenced of it for 63 months. And in 2018, that's when the board filed the accusation on me. And I left prison 2020 of March. But yes, I was charged.
Yeah, but see, we don't have any information on, all we know is stalking. Like, what were the circumstances of that case? Because it makes a
Oh,
big difference when we're trying to figure out if you've been rehabilitated. Like, I don't know,
oh,
there's lots of
okay.
reasons why you might be accused of stalking someone. So what were the circumstances, if you don't mind, just briefly?
Oh, you want to know why I did it or what
Mm,
happened?
Briefly, yes, and please help me, Judge.
I think the underlying question is, what did you do that for which you were convicted?
Yeah,
What were you convicted
and
of doing?
of stalking and harassing the
I think the difficulty is those are legal, that's legal jargon. What did you do? What did they accuse you of doing? What conduct um, was it
Your
that
Honor,
you engaged in?
Your Honor, the question was, what did she do? Not what she was accused of doing, but just give us a
Well,
narrative. On
yeah,
this
oh,
day,
yeah,
this
yeah.
happened. On this day, this happened. What did she do that resulted in this
Yeah,
conviction? Not-
that's a better way of saying it, is what did you do?
Yeah, so there's the specifics of it. I don't even honestly I don't even remember most of it, but I didn't even read it until Amber sent that to me, and I literally went through it and was like, oh my God, I can't believe I did that. Because I tried not to think about it, and I wanted to put this all past me. But yes, I was initially how this got started was my husband was, he was a doctor who's an anesthesiologist, and he got a phone call from a doctor. It was a celebrity they were going to do plastic surgery on. And so when he left a message, he said, sweetheart, I think there's somebody's voice in the background. And when we both played and it said Scott James, it was the FBI agent's name. And I said, but the FBI is
Can I
not
object
investigating.
really quickly? The victim's name is supposed to remain confidential because of the sensitivity of his position. It's been redacted from all of the documents. So if I could just ask the court reporter to refer to this individual just by his initials of SJ.
I'm sorry. Yes.
So it sounds like, Ms. Whitler, you're requesting a protective order?
That's correct, Your Honor.
Okay. I guess so I
Yes.
could issue the order and it's clear what is the victim's name so we know what needs to be protected.
Scott James.
So is it common spelling SCOTT
That's correct.
and then JAMES?
Yes.
Okay, and do you want him referred to by initials or another moniker such as victim or person?
SJ is fine. That's what was used in the indictment, and so I think that's fine for these purposes as well.
All right.
Yes. And I apologize. I'm sorry. I didn't.
Ms. Kudagulian, any objection to the protective order?
No, please go ahead.
All right, I'll go ahead and issue the protective order and then instruct the court reporter that if a transcript is ever ordered and prepared, then the victim's name should be replaced with his initials. And then I'll go ahead and issue a written order after the hearing and make sure the parties get that.
Thank you, Your Honor. I appreciate it.
This report is a live meeting that's going to be on our website for many years. So how does that change?
I don't think there's anything we could.
If that was supposed to be on the record.
Yeah, it's fine that it's on the record, because that's not. Okay. Yeah, there may be, well, that's something we could look into. But I guess for our purposes from now on, to the extent we can, we should not use the name.
Yes, and I apologize. I'm sorry.
Careful. Yeah, okay, go ahead. So if you want to continue.
Yes, and so what happened was my husband said, "Oh, it's this guy SJ, the one that works for the government. I don't want to name the agency." He said, he said, "Why would he listen to my phone calls?" And I said, "I don't know. I'm not sure." And then after that, what happened was I started getting strange text messages about my husband, me, and it was very specific. So I was not sure what was going on. And I said, "You know what? I'm going to look into it to see what's happening." He said, "Yeah, it's really strange because we're not under a federal investigation. No one should be listening to my phone calls or monitoring or do anything else." And later we found out that yes, that agency admitted, they said, "No, we were not investigating. So we don't know why somebody would listen to your phone calls." But nonetheless, after that, I started getting emails and texts and all these weird things that were happening. And then I told my husband, I said, maybe it's related to this guy. I said, I know I spoke to him. He told me a little bit about his family. I said, maybe it's related to this guy. I said, I'm going to just do my own little investigation to see what's going on. And all that time that I knew about him since 2000, I believe it was 2005, nothing ever happened. I never did anything. And I knew of him because he told me when we spoke, he introduced me. He said, "Okay, this is what I do. I'm investigating so-and-so, and I don't want to talk about it. But so we talked about it, and then after that, I never did anything until I think over like 5, 6, 7 years passed, where I started getting these emails and texts, and it was very specific. And I said, "What is going on?" And like I said, I told my husband, I said, "I'm gonna just do my own investigation to look into it." And then that's when I just looked online. I was like, "Is this related to this guy?" Because it's very specific. These are things they were emailing me that nobody would know. And then, they made the error of doing that, and I should never have done that. And then I went online. I found his wife, and and I said to her, "Are you emailing me? Are you obsessed with me? Or what do you want from me?" And and then later we found out that she literally was a victim. She didn't know anything about it. And he also said that he said, "I don't know what, I didn't do anything." He said, "I didn't call and, you know, monitor her husband's phone number." He said, later one of the agents, from the agency, he gave me a paperwork that said, and I don't want to name he said it's only for the eyes of this agency. But there was a notice, and the agent said, "Yeah, I investigated him because we had to investigate. Did he unauthorized monitor you or whatever?" And he said he told him that he sent someone to come talk to me, which was really strange. And I didn't know that. He said, "Yeah, he sent someone to talk to me." He said, this government agent, he said, "Yeah, but I followed through and that was not verifiable. So we don't think it was true." So there were many strange things that were happening. And I myself was, I don't know why he would send someone to talk to me and about what, but somehow I was connected to this. And these text messages, these emails that were coming in, like I said, it's not their fault, it's my fault. And I should have paid attention and whatever. And as I told the FBI agent initially when he was investigating and came to my house and spoke to me, I said, whatever email that I thought maybe his wife was sending me, I sent it back to her. And he said, no, she knows nothing about it. And he also says that he's not involved. He left the agency. He's working somewhere privately. He has nothing to do with it. And they're denying everything. And he said, and he said, it's your fault. You can't do that. You can't look for someone. You can't email them. You shouldn't have texted them. You shouldn't have done your investigation to see what it was about. And I agree. I should not have. That was my mistake. He didn't deserve that, and she didn't deserve that, and I feel very badly about it. I don't know what I was thinking, but as I said, it was things that were happening, and I was asking people's opinion at that time, my friends and family, and people were saying, "Well, it has to be this guy. Who else could it be?" But that was an error. I should not have listened to them, and I should not have taken that into my hands and gone on and investigate and send her emails, telling her, "Are you getting divorced?" You telling me I'm getting divorced, so that was foolish. That was foolish, and she didn't deserve that. And she was frightened of it because she said, "I don't know her. I don't know why would she send this to me?" And he also he denied everything. He said, "No, I left. I know nothing about it. I never talked to her." So but whatever the circumstances was, when whoever it was that was sending me, for whatever reasons it was, I have to take responsibility because I should not have gone online after all that I've known him for all those years. And even if he was explaining about his family and everything, I should not have done that. He didn't deserve that. She didn't deserve that. His family didn't deserve that, because obviously they got, rightfully so, they were scared and they were like, "What does she want? Who is she?" So I take responsibility on that I emailed them. I shouldn't have said derogatory things about her or the way she looked. But as I was telling the FBI agent, I said, "Yeah, whatever she sent me, I sent her." I shouldn't have not even said that. That was wrong. I shouldn't have said it's tit for tat. That was wrong. As an occupational therapy assistant, you have to be professional. I have to keep my cool. Why should why should she hear that? Why should they suffer? Why should she fearful of me? And she didn't even know me. Whether some of these things, whether he was doing something or hiding or whatever it was, it doesn't matter. I should have taken the steps. I should have gone to the police if I thought he was harassing me. I should have called his agency, and if I thought I'm getting emails from him or text. That's what I should have done instead of taking it into my own hands and emailing her and saying, you're like this, you're saying I look like a man, you look like a man. It's unprofessional, and until now I'm disturbed by it. When I read it, um I'm embarrassed by it. It was wrong at many levels, and
Right,
yes, I was.
Ms. Kudagillian, let me interrupt now because you're starting to repeat yourself.
Okay.
Madam Vice President, did you get an answer to your question?
Yes, I did.
Okay.
Thank you.
Do you have any further
Thank you.
questions?
Yeah, just one more question. Thank you
Thank
for
you.
that. I appreciate that.
Thank you.
Um, when the DAG, I'm sorry, can't remember your name. When the DAG asked you about therapy, you said something about you had gone through enough therapy, but then shortly before that, you had testified it, if I heard you correctly, tell me if I did not, that really all the therapy you had gone through was your initial assessment for the board and then
Yes.
a little bit of therapy right after you got out of prison, which quickly you were let go by your therapist who said you didn't need it anymore. So it sounded like you didn't really have a lot of therapy during your testimony, but then later you said you had plenty of therapy. So can you
Yes.
explain exactly how much therapy you had?
Yeah, so initially, as I said, so in 2016, when this happened, the courts usually require it. So when I went in there, they did an assessment, and he said, "Well, I'm going to have you go to a couple of sessions." She wasn't even a therapist; she was a counselor. So he said, he said, "I feel like there's a misunderstanding that you're just going through something and you misunderstood it. You took it in your hands. It's not that serious." He said, I'm just going to have you go speak with a counselor. So I did go speak with a counselor, and we spoke about it. And she said, yeah, this is embarrassing. I said, I agreed. I realize that now, how horrible it is. And then after that, and this is a court ordered, by the way. So after that,
So that was like
after I,
excuse me, that was like one meeting with this person or?
no, I believe it was for a month or two. If I'm not mistaken,
Once a week or a month, once every other
yes,
week?
once a week, once a
Okay.
week. Yes, once a week. And so she saw me once a week. And she's the one who set up, who initially she did the assessment. She said, you don't need a lot. You're a logical person. She's like, I'm just gonna do it once a week. And then when I feel she said, when I feel you should be not seeing me anymore, I'm going to discharge you. And that's what she did. And so it was short. It was, I think, a couple of months only. And then after I went to prison and after I got out, David said, well, because it's traumatic, he said the prison's traumatic. He said, I want you to go see the same court-ordered therapist, counselor, and talk to her. I just want to make sure you're okay. I said, okay. And so I called her, we spoke. I believe we did again a month or two. And it's based upon what they believe. And she said, yeah, you don't need to see me. She said, you're doing great. I'm gonna let your probation officer know. She's like, you're logical. You realize this was a horrible mistake. And you want to move on. She said, I don't believe you need it. And I'm gonna tell him. She said, if I do, I will continue on. They're paying for it. The court's paying for it. She's like, I could see you. But she said, you don't need to. She said, I feel confident that you can move on.
Okay, so just, I want to make sure I understand. So just so we're clear, one therapist, perhaps 3 or 4 months of weekly therapy. Is that kind of where we're
Yes,
at here?
yes,
Total? Okay.
yes,
Thank you.
yes.
I have no more
Mhm.
questions. Thank you.
Yes, thank you.
All right, Madam Secretary, any questions?
Yes, thank you. Thank you so much for the information that you're providing. I do have a few questions. Um, First, just about the continuing education.
Yes.
In most settings these days, electronic documentation is a common practice. I did not notice any continuing education related to electronic documentation. What about also along with that, current billing procedures in typical OT settings?
Okay, the billing, you said billing, and I'm sorry, what was the first one?
Electronic documentation.
Electronic documentation. I will have to look through. If I didn't take classes for billing or electronic documentation, I certainly can do it. I have a membership with Occupational Therapy Board, and I continuously take courses. I'm trying to. I will have to go through it later. I'm sorry, to see which one. I believe I took something that said billing, but if not, I can certainly take classes. As I said, I have a membership with occupationaltherapy.com, and I can do it, and I can also do it with NBCOT, and I could send that to you.
Part of why I'm asking is this is more of a hands-on skill that really wasn't around in the initial years when you were practicing. So it is a fast-paced, high productivity environment. And I appreciate that you've been using podcasts and readings and things like
Yes.
that for stress management. I'm just wondering, in those high stressful tasks that are new and familiar, what other stress management strategies do you have in place in the moment if you were to return to a clinic under a new license?
I do also, I wanted to get a membership with a gym, and I go initially when all this happened in 2020. I was like, I want to go to gym. I want to, go out and I want to exercise. I want to go to social groups, just visually, just talk to people, meet new people, get opinions. And unfortunately, COVID hit at that time, so everything was restricted, as you may know, and everything went online. But even now I have access, which I was planning to do. I've just been, as I said, so busy with the wedding content. I have not been able to go and exercise or get a membership or do other techniques. But I can certainly, I'm willing to do it, and I will do it. I will certainly do it. There's other ways. There's other programs that people have, a lot of these followers, including religious groups. There's some that I signed up for where you do a visual exercise, a visual prayer group, and I do have signed up with them. So I do try to follow through as whenever I have a chance, I do try to do that.
Thank you. And that leads me into my final question is the types of personal and professional support systems in that who are able to be at the ready for you so that high stress does not distract you from your primary focus of, ethical practice of occupational therapy.
Yes. So the as I was mentioning in around 2020 when I came out, I literally was around extreme high stress where I had to work with different people, different personalities, and deal with concerns and problems with different religions, and I had to handle it, and that's why I was mentioning it very earlier on that I had to learn how to handle all the stress, all this extreme different problems in different areas from different countries that I was getting, and I have to problem solve it and keep myself calm, and try to come up with a solution. But I also have a physical therapy friend, physical therapy assistant friend who work with Genesis Healthcare, and they said they can't wait until I come and we can continue what we did before, which was we would go out with them, socialize, and unfortunately all this stopped with my therapy friends. But everyone's excited because I want to get my group going again, and go out with my therapy friends.
Okay. So, okay. That's
I
all I
would say
have for
they're
right
my
now.
mentors.
Thank you.
Thank you.
All right, Mr. Greco, any questions?
Yes. Good afternoon.
Good
Were,
afternoon.
Mr. SJ or Mrs. JJ or their two young daughters ever your client?
No.
Are you sorry for the harassment and intimidation that you committed over that 6-year period or 6-month period between April of 2016 and October of 2016?
Yes, of course, of course.
Why?
And why do I'm sorry, why do I apologize?
Why? Give us a sense as you've said, if I understood you correctly, that your husband was suffering from an aneurysm, that you had heard that you were, you thought you were being taped. Are those, did you have any romantic interest in Mr. SJ?
No, I did not have romantic interest in SJ, and it was my mother who had aneurysm, and my husband, who was then a doctor. He now passed away, but he was a anesthesiologist. He was a doctor, and yes, the recording was when his doctor friend called him.
Well,
But
can
no,
you
I
give us
don't.
a sense, sorry for interrupting, but can you give us a sense of what was your rationale as you were calling their church, as you were
Yeah.
calling the franchise tax board, as you were calling and finding out where they, attorneys, divorce attorneys,
Yeah.
what rationalization were you using in your mind that justified you doing that?
You're absolutely right. There's no rationalization. And at that time, as I said, I was going, whatever stress it was, and it was wrong
Let me
of me
stop
that,
you for a moment. Let me stop you.
yes.
I appreciate that you're agreeing with my perspective today, but
Uh-huh.
I'm asking you to go back because we're trying to figure out, are you
Yes.
still that person? Do you have insight into the damage, harm that you did to that particular family? Can we trust you
course.
with other people? So I'm asking you, you did it not once, but over a long period of time. And I'm asking you, what was your rationalization? Why did you rationalize that it was okay to use aliases um, uh, and identify yourself under other names? What was going on in your mind?
Yeah, and that was what was going on in my mind. Is that was a part of the stupidity that, of course, it's my mistake. But at that time, like I was telling my husband, I told the investigator, I said I just tried to come up with different names to investigate this matter to see what's happening. Who are these people? What do they want from me? And now, when I think about it, I mean, it was foolish. I should have never done that. I don't know why I was thinking that I could investigate, have different names. And that I'm going to get information to find out what's happening, and are they harassing me, or does this guy like me? Do I like him? What's happening? Is he trying to say something to me?
So could
And
you
that was
give me
my
a sense?
fault.
Hold on. Could you give me a sense why on July 22nd of 2016 did you feel it necessary to call their church and ask to speak to their pastor? And why did you feel it was part of your investigation that you needed to pass along that they came to church and pretended like they were good people, but they have very dark demonic secrets? That doesn't sound like an investigation. That sounds like character assassination. Give me a sense as to what that thought process was.
Yes, you're absolutely right. That does sound like character assassination. And what happened, I believe, initially, when this happened, is in July, August, September, I believe. Or initially, when this happened, after I gathered the information, then I said, "Oh my God, it's probably this guy or it's his wife." And they're so twisted. Why would they send me all these things? And then, why would they do that? And they're trying to prevent me. They're trying to play games on us. They're trying to sabotage me, and they're so so diabolic. That's so twisted. Why would they do that? And then that's when, in my mind, I was like, okay, I'm just gonna call them and tell them that they're really mean people, and whatever they're saying is not who they are, and they're not just, But that was wrong. That was absolutely wrong. I don't know what I was
Okay,
thinking. Now
let
I'm
me stop
embarrassed
you
about
there.
it.
When did you realize that it was wrong? When did you realize that, was it, you were indicted? The indictment was returned on January the 4th, 2017. Did you know it was wrong by January 4th, 2017? Or were you still in your mind thinking, you're a victim, and I'm a victim in all of this? What was your mindset?
After that because I only did it after 6 months, and I stopped, as my attorney said, because as I was saying, and not to give an excuse, where I was also asking friends and family, what do you think? Do you think this is him? And they were like, yeah, it must be. They're so twisted. Why would they do that? And so, but after that, it was only 6 months, and then I just cleared my head, and I said, no, something's not right. Why would he do this? I can't listen to people. Why would she do this? Why would he?
Let me stop you right there. You can't listen to people. Isn't this all from your head? Was there anybody else who was telling you that JJ or SJ or JJ was doing anything to you? Wasn't this 100% you? Or are you suggesting there was somebody else that also had this perspective?
Yeah, so at that time I had a friend who was also a nurse. She was an LVN, and I was explaining to her, because when it happened, I said, I need opinions. What do I do? This is so weird. I'm getting this harassing emails, and I would show evidence, just literally, like, look at this text, look at what this person is saying. And I believe I said the same thing to the FBI agent. I said, look at these emails. And my attorney, by the way, was also trying to investigate. She said, I'm going to try to investigate to see. I'm looking at these emails that someone literally is very specific to you.
When you read this, hold on. When you read this indictment, which I'm sure you and your attorney did,
yes,
soon after January the 4th, 2017, did you recognize that what you had done was serious, and that at that point, did you realize that you were wrong, that it was not this agent that was harassing you, that whatever rationale, whatever was going on in your mind was wrong?
absolutely. Yes. Yes.
Okay, well then let me ask you, if that is true, why did you and I'm referring to Bait Stamps 173, on October 17th, almost 10 months later, you write, hi Janine, hello Janine. I want to give you an update on my case. I received a letter from the OT board, Nancy Short, regarding my status with arrest and case. I'm sending you the paperwork from the case. This case is still ongoing, and I'm currently in communication with FBI headquarters regarding my arrest and investigation of people involved in this case. Because initially, I was the one who filed a complaint on the agent involved, stating I was being harassed and stalked and was going to do my own investigation. Now I'll skip down a couple of, you write, he is currently being investigated by his agency, and we are still waiting for those results. That is 100% false and inaccurate that you wrote in October of 2017, correct?
Well, I don't know the specific dates and specific things, but let me tell you what happened. So initially, when this
I'm just
happened,
asking, did you write that email?
the email that I wrote was based upon whatever the attorney was telling me, because she said we're still waiting to get records, I believe.
So it's your position you didn't write that email, that your attorney wrote that email?
Well, whatever she suggested to me at that time, as you may know, I said to her, what should I say to my board? And she said, we're still waiting to get his phone calls because you had communicated with him and he's denying everything. She said,
So was that
we're
email,
subpoenaed.
do you deny then that that email was correct? Do you believe that at the time, October of 2017, the statement that the agent was under investigation and that you were waiting to hear back from the FBI, that was false, correct?
Well, it's whatever my attorney said. She said, I'm waiting to get his phone calls, his actual records, because they're
No,
investigating
I'm
him.
asking you, was that statement true or false? I'm not asking you what your attorney said. I assume that your attorney wrote it. Let's assume what you're saying is 100% true.
Uh-huh.
Is the statement true or false?
At that time, I can't go back to remember how specifically I felt. I believe, and I also probably felt that I said, I don't know, maybe this is not him. Maybe this is I don't know what's happening. It's my fault. And she said, well, there's an investigation going, and this is what you should tell them, that there's an investigation going, and they're checking on him and his phone calls, and that's how it's going. So that's what I did. I personally, if you're asking how I personally felt, as attorneys, how attorneys are, attorneys always go, well, no, this is evidential. They're investigating him. This is what we're waiting for, and this is what you should say. And that's what I did. But if you want to know what I personally thought, I don't know. I said, well, if you think, there's evidence of it, and it's coming from them, from their phone, or these emails are coming from them. She said, well, we're subpoenaing, they're investigating him. She's like, there's phone calls of you communicating with him, and there's the FBI is the only one who has those records. We can see, oh, did he email, did he text you? Because he was
Wait,
denying it all.
You know what the truth, that you're the only one that sent documents and communication to him, correct? I mean, you know that, as you sit here right now, you have zero evidence that SJ or his wife, JJ, or their 2 young children ever sent any communication to you, correct?
Yes. Yeah. No, of course I don't have any evidence. After that, the attorney said, well, listen, we're waiting for it, but she said the prosecution wants to close this case. Let's finish this, and let's and I said, absolutely, let's do it. And so, I have to go by what attorney said. If attorney is telling me, by what's the point of it? Let's just finish this and heal and move on. And I said, okay, well, let's
So is your
let's do that. But of
position that
course,
you pled guilty and you were not guilty?
no, of course I was guilty. I was guilty because I did it, and it was not his fault. And as far as my attorney asking to get evidence, that's on her, because she has to speak carefully. She was saying, well, there's phone records. He's denying you ever spoke to him, but there are phone records, and we're waiting for it, and the FBI agent so and so is investigating him. So I had to go as by whatever she was suggesting, but of course, I have to take blame for it, because then she said, no, let's just, she said, there's no records. It's not coming. I don't know if they're holding the phone numbers. We're not getting anything. She's like, there's no point. And I said, well, obviously, well, there's no evidence of it. If there's no evidence of it, and, then that's what it is. I said, but it's my fault, because I should not have done that. I should not have assumed anything. I should not have, harassed them. They didn't deserve it. They didn't deserve it. So of course I took full responsibility. And of course I was telling her, I said, I feel guilty. I should, even if we thought he sent something or somebody sent something, they did not deserve it. No one should be harassed like that. I should not have insulted his wife, his family. What was I thinking? So no matter what, I should not have done that. I should have either filed a police report and said, please handle it, or that's it. Not, continue this on and on and on and on. And I think the suspicion, those conversations when they went with Agent H, and that's all I'm going to say. I don't want to say his name. The reason she was assuming this.
Ms. Kutagulian, you're really going beyond the scope of the question.
Okay, I'm sorry.
So,
Okay.
I have no further questions. Thank you.
all right.
Honor.
All right. Ms. Swire, any questions?
I do, and I think just to follow up to some of the, thank you for all your information that you've given us today.
Thank you.
A lot of your continuing education and a lot of the reported rehabilitation efforts that you've made have to do with a lot of self-directed learning, reading, podcasts, those kinds of things, more of the passive learning that's been available to you, right? And as you know, as an occupational therapy practitioner, it's a very active, engaged, and a social, right? A lot of interaction involved in a lot of your rehabilitation, and a lot of your learning has been reported listening and passive receiving of information. Can you describe more about what active actions you've taken or active different behaviors you've engaged in to assure us that you're ready for that interactive approach? How do you integrate what you've learned in those podcasts to actual interactions with people?
Oh, are you asking if I did anything throughout that time, like physically go to work
Now,
for?
no, I'm saying, how are you integrating that learning, right? So you've done a lot of reading and podcasts and those types of things, and you're reporting that as self-management or self-reflection and part of your rehabilitation process. How can we be assured, what active actions are you taking to integrate that into action when you're how can you give us an example of how you have improved your interactions during conflict, or your interactions during disagreements, or interactions during with people?
Yes, absolutely. So as in the beginning, when I was explaining that this is me working with different nationalities, different religions, and taking all these courses and all these things that have to do with ethics, decision making, the podcast, how they've helped me is even now, as I was saying, when I post things that are opposition to political or religion, if I post a Jewish wedding, or if I post a rabbi, immediately I'm getting threats, harassing threats and mean comments. And all these courses that I took and that I continue to take, they've helped me because I control myself, because I have to, coordinate that and be calm, and report that person or block that person, or, not to communicate with them. As initially when this started happening, I said, David, how should I handle this? These people are threatening because I'm putting different religions. They're threatening to kill the person. They're threatening me. And he said, don't communicate with them. You know what I mean? He said, that's part of your thing.
Right.
Don't communicate. Don't assume anything.
And if I could
Just
stop you there for just a second. So you're speaking on responding on a virtual platform asynchronously, right? So they post it,
Yes.
then you have some time to think about it, and you can respond. What about in the moment? Because as you know, as an occupational therapy practitioner, you deal with people on a
Yes.
right? So in the moment, how do you handle yourself, or how have you integrated and demonstrated some of this rehabilitation with direct communication and contact with people immediately?
If you mean like live in a moment, the communications I had with wedding planners, as I'm talking to them on a phone, or if I have to see them, if there's a problem or the bride does not like something and there's this, becoming problematic. So I have to solve this issue, and that's part of the treatment that I apply, that I have to remain calm. The bride's not happy with the video. She's not happy with the music. And then I continue and I tell them, if you don't like something that we posted, let me know. We'll re-edit, or even if it's last minute sometimes, or even if we post, they want to delete it, I have to coordinate that behavior by, talking to people visually and talk one-on-one and tell them, okay, if you're not happy, we're going to solve this issue. This is a problem that we're going to solve. Don't worry about it. And I try to, to make sure that doesn't grow into a bigger problem. As you could see, with brides are emotional and they get upset. They're very anxious. Their family members are. So I immediately have to get that occupational therapy classes and all these de-stressing. And I have to tell them, don't worry, we'll solve this. We'll remove it. We'll re-edit, even if it's last minute. We could do this. Don't panic. I'll stay 2 o'clock in the morning and I'll upload it and you'll get it on time. So that's how I problem solve, and people are happy and they're thankful. But I always tell people, if you don't like something I do, don't worry about it. I'll stay 2 in the morning, and I'll complete it to make sure that it's not problematic, because that's one thing I learned. I want to solve all
How
these
do you
issues.
foresee this impacting when in an exchange with as an OT? So you have some experience practicing as an OTA. Where do you
Yes.
foresee this in your future?
Yes, absolutely. So we're and literally I was telling my family, I said, nothing compares to an upsetting angry bride, or the wedding content creating field versus therapy. I said, because the patients are so much easier to handle. They're so much they're so much easier to work with. And that's how this has helped me, because when people get aggressive or they're confused or they're angry, I'm going to apply that to my patients. If a patient's not happy, if they're upset with a care, or something's going on, or if they have psych issues or physical issues, I'm going to work on, to see how we're going to solve this, and work with a multidisciplinary team, if need be, which we do in occupational therapy, to address issues. And I've learned one thing, especially with the brides, is that when there's an issue, we let's not let it grow bigger and bigger. Like, initially, let's go head on, and then just solve this and make sure that it's a solvable issue and that they're happy. And this is the same thing that I'm going to take into my occupational therapy. If there's a patient who's not happy, or family, as you may know, I've experienced also that if patients come, family members have questions, they're upset, they're confused about the treatment, but keeping a calm head, talking about it, giving them, printing out paperwork, which I used to do also when patients' families were confused about the treatment. What kind of treatment was this? Why is this? And they would get nervous, and where, and so I had to explain to them, they're transferring to the hospital, they'll come back, we'll continue the treatment, don't worry, and this is what we're going to work on, and so this is what I'm going to take, all this
thank you.
experience from the brides, I'm going to take that to patient care.
Thank you.
All right, I believe I've gone through the board once. I'll circle back. Madam Vice President, that's what I was going to do. Go ahead.
Okay, thank you. One quick question. You've mentioned someone named David several times, so I'm assuming he's part of your support system. Just could you tell us who that is?
Yes, David actually was the initial probation officer that was assigned to me initially. And I believe it was in 2020, I was in a halfway house. September, he took over. And that's when, he took over. He said, I'm going to be the new probation officer. And he said, okay, so, whenever there's a concern with business or whatever is happening online, if you think something's a problem, immediately let me know. And that's when I would say to him, David, I posted a wedding or whatever, and I'm getting threats
Okay.
on that person,
I got it. Thank you so much. Thank you.
Thank you.
All right, any other questions from any other board members? Hearing none. All right, Ms. Kudagulian, thank you for your testimony.
Thank you.
You're excused as a witness.
Thank
And
you.
it's my understanding you don't have any further evidence in terms of documents or witnesses, correct?
No, I don't.
All right, so I'll take closing arguments. Ms. Whitfler?
Thank you so much. The Attorney General isn't going to make a recommendation in this case, and is going to leave, this will be at the board's ultimate discretion. But I would like to point out just a few things that have struck me throughout these proceedings. Ms. Kudagulian's continuing education work is very impressive. Getting the national license back is obviously something that should be commended, and I believe that she has conducted herself today forthrightly and honestly. I would recommend or a concern that our office would have is simply that the rehabilitative efforts, done in the form of the self-help books and the podcasts, while certainly those are very valuable, they aren't really a substitute for therapeutic services, especially given the very serious nature of the charges that led to the original accusation. And some of these, if we look at at some of the rehabilitative books, a children's picture book by Kosh Patel is not a particularly is not particularly rehabilitative. Donald Trump's instructions for conducting business doesn't really have a lot to do with understanding the causative factors into a felony. And so for those reasons, our primary concern would simply be that Ms. Kudagullian have adequate insight into the causative factors of the offense that led us to this point, and to ensure that should she return to practice, that she can do so in a safe fashion.
All right, thank you. Ms. Kudagullian, your closing argument?
Yes, Your Honor. I wanted to say that the matter of the revocation license. Okay. I wanted to say that I've implemented structured safeguards in my life, including ongoing ethics education, clear professional boundaries, disciplined decision-making practices, and commitment to documentation and accountability in professional settings. My conduct over the past several years has been stable, lawful, and consistent. This was an isolated incident. It was an isolated matter in my life. It does not reflect 20 years of safe clinical practice. It does not reflect who I am today. And the revocation incident that happened, the licensure responsibility with direct patient. Of course, I accept accountability for my past conduct and for the impact. I'm sorry for the noise. For the I'm sorry. I'm sorry about that. For the impact that I have. And since 2018, I just want to say that I've been focusing on professionalism and growth. I completed all court ordered conditions, supervised, and I was released without violations. I was constantly being monitored, and as I said, my NBCOT certification is active and in good standing. And I earned a bachelor's degrees, and hence I was taking the President Trump's book. That's why I was reading it. It was business related. And that's why I mentioned that. And the other courses that I took, I wish I was able to. Initially, when I came out, I said, "Oh my God, I want to go to work. I want to even volunteer. Just so I can have experience. More because I left the field and I was in prison, but I could not because I had this on my record, and I asked facilities if they would take me, and they said, well, you're still on probation. That was the main concern. They said, you're still on probation and we can't take you even for a volunteer, because I would have loved to had just one-on-one experience, and then hence show the board and say, well, I went to work and this is how it was. But under the circumstances, I was not able to. The hands were tied literally because of this prison, this whole thing that happened. And I was restricted. There's even now for me to go study certain things like social work or other fields, that's constricted because of this incident that happened. So, but I wanted to do more. I wanted to do more active things in healthcare. But like I said, unfortunately, because of the criminal record and I was on probation, they wouldn't take me. So hence, that's why I said, okay, well, what can I do? And I did the wedding content creation because that didn't really require a background check, so people just wanted to work with me based on honesty, and they wanted to give me a chance. And I'm very happy that people trusted me and gave me a chance, and I tried to grow from that, and and try to do whatever I can. But I'm prepared to return to practice, to safely, ethically, and with deep respect for the responsibility of my license that it represents. And I followed through with everything. And since as I said, since 2016, when this incident happened, to 2018, I was working in nursing homes, in different nursing homes. And then while I was in prison in 2018, I, of course, took courses, whatever I could under the circumstances, because it's a prison. And also, just to mention, initially the judge didn't want to, or the prosecution, they didn't want me to go to prison. They wanted to put me in a program. And they were going to put me in a program, which I thought it was a trial program where people stay out and they work in the community. But they were full and I couldn't get in. So hence, I ended up in prison. And of course, it was a low-level prison, but because this was a nonviolent crime. But nonetheless, I tried working. I tried working on myself. I took whatever I can under the circumstances that I have a criminal record, to better myself. To do the wedding. I didn't know what to do. I was like, I want to do something. I want to better myself. I want to prove that I'm ready. And with the criminal record, my hands were tied. So I did the wedding, and not to repeat myself, but I tried everything I can. But I think my me speaking with other people, other delegates of other countries, and having them trust me, I think that reflects something that, to work with different religions, different backgrounds, and have them give me an opportunity, or even send me private videos of their families, their children, their confidential home information. There's a lot of confidential things. These are top level people, for them to trust me. And no one's had a problem. No one said she's stalking me. No one's, no one had a complaint on me. No one has a complaint on me. And that, I think, says something about part of my rehabilitation, that I'm able to work with people. I take confidential information, be professional, and make sure people feel safe with me and safe around me. And I hope that you take that into consideration.
All right, thank you, everyone. So that concludes the hearing. The record's closed, the matter's submitted, and we are off the record. Let me check, Madam Court Reporter, are there any spellings you need?
No, I think we're good.
Okay, and if I could get a page estimate?
95.
Okay, so Ms. Kudagulian, what happens now is the board will meet in closed session to deliberate about your petition. So you will not receive a decision today. And then after the deliberations, a written decision will be prepared, and you'll receive a copy once it's issued in the future. In the meantime, my office will send you a court reporter billing sheet for today, and that just has the information about the court reporter in case you want to order a copy of the transcript. It has the information you need to contact them. And given the hour, it'll probably be tomorrow when you get that. They'll send it out to you by email. Okay. Do you have any questions?
Thank you.
At this time?
No, that's about it. I guess I'll wait until I hear from you.
All right, thank you. And then, of course, Ms. Whitler, OAH will send you a copy of the billing sheet as well for your records.
Thank you very much.
All right, if there's no further questions, that concludes the matter. I thank you for your time and attention, and you're welcome to disconnect this time.
Okay,
Thank you very much,
everyone.
everybody.
Thank you.
Take care.
And Madam President, I'll turn it back to you.
Thank you.
Thank you very much, Your Honor. So at this point, we're just going to adjourn the meeting. I mean, we're gonna go into closed session. We're gonna reopen just to close it again. So no more public participation after this. And thank you so much but tomorrow we'll continue with our agenda at 9:30. Yeah. So thank you so much for everyone for being here and attending our meeting. Thank you, Samuel. Bye. Okay, it's 4:11. The meeting is adjourned.
Let's take like a 10-minute break to,
For
Yeah, let
everybody.
the-
break and